Yes.
May I please, Your Lordship? Lordship, in item number 32, we have filed an affidavit of service. That may be called for 2 minutes. I'm so much.
May it please your lordship. Item number 26, order matters, but it is infractious. My lord may dismiss it. WPC 2393.
Mr. Nicholas Swami, the General Counsel, if it on behalf of the petitioner, submit the petition has come in from taking into account the above petition and still order to.
I wish to mention item number 33. I got a review petition. I'm not taking in this case, item number 33. In this case, my lord, explanation
30?
33. My lord, in this case, my lord, explanation file an affidavit also. We need to file a reply also. We could not conduct that file. Which time may be used?
The counsel, you must be aware. Are you appearing before this court for the first time in your life?
It's the order matter. Let's
I
wait.
don't permit filing of a reply at this stage. When a matter reaches, then you make.
May it please, Your Lordship. I beg to mention a matter for motion, Lordship. It was filed on 29/10.
When,
It's a tender matter.
when do you want?
Lordship, if Lordship permits tomorrow, Lordship. Because
With the urgency, but
Lordship, what has happened, in one matter, I have been technically disqualified, financial bid has opened. I challenge my rejection order. In a similar tender now, they are about to open the technical bid. On the same clause is there. Therefore, Lordship.
Your lordship, with regard to item number 33, in the affidavit in opposition that we have filed, there's a inadvertent error has occurred. Some unrelated document has been tagged along with that. So can I be permitted to withdraw that, take up
now the matter.
much?
For withdrawal, item 41.
Please, Lordship. Lordship, I'm under instruction from my client to withdraw this matters. I'm under instruction from my client to withdraw this matters, Lord.
You are there,
Oh,
you
Lord,
are a counsel in this petition. You filed a wakalatnama.
uh,
Have you filed a wakalatnama or not?
yes, Lordship, Ambora.
Embora will has to come. You are not Embora. Are you Embora?
No, Lordship.
Then didn't that come within the ambit of who is Bigo?
Bonusri Gogoi, my
Then?
son.
They have to come. Can't withdraw like that.
On behalf of PTC.
You are appearing for whom?
On behalf of the BTC, on behalf of
We can't allow this to be withdrawn by a person who has no business out there. Get hold of them. You want to withdraw or put it some other day?
Lord, if Lordship allows to withdraw the petition.
Absolutely no. Not like you with you. It has to be by the council who has signed the wakalat.
Then Lordship on some other day.
Okay. At the request of the council for the petitioner matters can be drawn to be listed of the 6.
42.
Same,
Same.
same.
Quick. None has appeared on behalf of the petitioner on call. Accordingly, matters can be shown to be listed of.
For motion, item 1.
Well, it is under consideration. Then will be after 4 weeks, the representation.
How can I give you 4 weeks? Court has given you 1 month.
Yes. Then Lordship will give me at least 3 weeks, man. Lordship will post it after 2 weeks. By this time, my lord, I will advise them to, my lord, dispose it of and place the order, etc.
Mr. P. Gogoi, the learned counsel who represents the NHA, submits that the representation of the petitioner is under consideration. An effective order will be passed within a period of 3 weeks. Taking into account the above, this matter again on 1st of December 2025.
Obliged.
Like,
Mr. Gogoi, kindly finish it off.
Yes, yes.
কিতাপখন গোটাই দিব।
Item 2,
Yes, what is this?
Lordship, petitioner NGO, your lordship, has conducted X-ray, your lordship, as per the order issued by the district Joint Director Health Services, your lordship, page number 26, Mekarli Peru.
Non-payment.
Non-payment.
Release কৰি দিব। এইটো non-payment order to the আছে notice issue কৰি on 28/1/2026 affidavit be filed on or before 21st of January 2026.
Obliged.
কিতাপখন বুজাই দিম।
3,
May I please? This is my lord, non-payment of contractor's bill, my lord. An amount of rupees, my lord, 2,14,938, my lord, is due, my lord. Lord. Here, my lord, two times parts payments are made, my lord, but final payment has not been made.
When did you got the last payment?
Last payment, my lord, on 21/11/2016, my lord.
And why are you sleeping?
My lord, thereafter, my lord, on several occasions, my lord, the demand was, proposal was sent, my lord.
Where?
My page 19, my lord. 19, then, my lord, 20, then 22, my lord. 3 times, my lord, proposals were sent, my lord, by the executive engineer, my lord, but final payment has not been made.
Then 2020, then why are you sleeping?
And thereafter, my lord,
Why are you sleeping for 5 years?
my lord, I have some difficulties, my lord, physical, my lord. I have some problem, my lord,
What is your problem?
for my lord, ailments, my lord. I
What
cannot-
were the ailments? Let's see where you mentioned.
No, my lord, I have not mentioned, my lord.
You're not done. You cannot come before this court like this. Who appears for the tribal affairs? Hard horse.
Yes, sir.
Now, Mr. Counsel, you have to wake up. I don't think WPT and PC department is there. Is the department there? The department has been segregated into 3. It has been bifurcated. To have the.
My
tribal
lord,
affairs.
original sanction order is at page 11.
So
my lord.
what? The department is not there. Who will accept notice for response number 2? This is the problem why you have come after such a long. Go before the civil court.
My lord, respondent. The government
Yes,
is,
Mr. Dhar. Nowadays, you don't have WPT.
WPT is not there, my lord, but I think, my lord, now this is called tribal affairs. Number 1 is there.
Number 2,
Number 2, my lord, this director is now tribal affairs. This part.
Number 3,
Vishnu Priya. No, man, then if it is Vishnu Priya, then again they are OBC. She will be OBC.
it is, how we do one thing, we dismiss your petition.
My lord,
You have come after such a long time.
my lord, I may withdraw my lord with liberty to approach this,
That is what I am going to give you.
approach the
And also you have no hope. 2020 this has happened. Therefore, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Ardhar appears on behalf of the Tribal Affairs Department of the Government of Assam. Mr. B. Gogoi appears on behalf of the PWD Department. And who is for finance? As well as for the finance department. The present writ petition has been filed by the petitioner seeking a mandamus directing the respondents to make payment of an amount of rupees 2,14,398. So it is relevant to observe. Now it is pertinent to take note of that from the materials on record, it's pertinent to take note of from the materials of the record that the petitioner was issued a work order on 5/2/2014 by the superintending engineer PWD, Silchar Building Circle, Silchar. It is the case of the petitioner. The petitioner, upon completion of the work, submitted bills to the tune of rupees 8,94,791 in the year 2015. And out of the same, an amount of rupees, certain payments were made. The last payment being made in the year on 18/11/2016. It is the case of the petitioner that an amount of rupees 2,14,398 is pending since 2016. And as such, the petitioner has approached this court by filing the present writ petition. This court further, from the material, this court have heard the learned counsel appearing on behalf of the petitioner. And from a perusal of the materials on as well as also the learned counsels appearing on behalf of the respondents. Mr. Ardhal, the learned counsel appearing on behalf of the respondent submits that in respect of dues, certain dues, alleged dues, filing of a writ petition after almost a decade takes away the defense, takes away a valuable right of the respondents to have a defense in as much as the relevant records would not be available for making necessary verification. He therefore submits that this is a case wherein this court ought not to entertain the writ petition in view of the judgment of the Supreme Court in the case of Itadata Dishnu, Chennai, TT, wherein the Supreme Court reported in wherein the Supreme Court had categorically observed that the equitable jurisdiction of the court under Article 2 to 6 of the Constitution ought not to be exercised when the petitioner had been negligent in approaching the court. on the ground of delay and laches. This court, upon hearing the learned counsel, finds it pertinent to observe that there is no explanation as to why the petitioner has approached after 9 years. There is no explanation also. Taking into account the judgment of the Supreme Court in so and so supra, it is the opinion of this court that the petitioner have the act on the part of the petitioner amounts to the petitioner had acted as a Kumbhakarna and Ribway Bankel. And as such, it is the opinion of this court that this is not a fit case for exercising the jurisdiction under Article 2 to 6 of the Constitution, for which this court dismisses the instant writ petition on the ground and this court is not inclined to entertain the instant writ petition. Accordingly, the writ petition stands dismissed. Before parting with the record, this court, however, observes that the dismissal of the instant writ petition shall not preclude the petitioner to approach the appropriate civil courts, if so otherwise permissible under law.
Item
Right.
4.
Yes, what is it? IOC, Forest, everybody, you have, yes, what is it?
He is challenging in cancellation order. That too is
Who
an
is the
order of
petitioner?
by IOC.
Wait, who is the petitioner?
He is the petitioner.
Let him argue.
My lords.
Yes.
May it please the court. My lord,
What is your case, Mr. Chakravarti?
My lord, I have come up before this honorable court a bit late. That is my first submission. That is in fact, that is my first
What
submission.
is your submission?
I have come before this honorable court a bit late. I have in fact been a year late in approaching this honorable court. What has happened, my lord? I participated in a process of selection for retail outlet dealership under IOCL through a draw of lot process. The advertisement is there at page 28, page
Group
30.
1, Group 2, Group
two.
Group 2. So you have a memorandum.
Group 2, my lord, the brochure contains the procedure. If your lordship sees the brochure at page 32, the brochure starts. And the relevant part is clause 4, Roman 6, page 36. Applicants having firm offer for a suitable piece of land for purchase or long-term lease for a period of minimum 19 years, 11 months, or as
Roman
advertised.
6 will only apply in the case of Group 1.
No, Romans 6, then
Really?
group 2, your lordship sees, group 1.
Mr. Chaudhary?
This is not his own land, therefore my lord take it to
Own land also lease.
lease my lord.
Group 1 is what? Those persons who have own land or 19 years, 11 months of lease. That's it. So wouldn't 4-6 come within the ambit of that?
Yes, it will come.
That he has a long-term lease. And 4-6 further says that if it is necessary, that if there are various co-owners, then all the co-owners has to be a part of the lease agreement.
Lease agreement.
So how do you come under Group 2?
Because I did not have the long-term lease then.
Okay.
So I had to get it from someone who has a land within the advertised allocated area. Now, my lord, this area that has been advertised, this entire area falls under forest land. Now, to have a long-term lease for any location within that particular area, I have to, in terms of the brochure, either go for a lease or an appendix 3 that is required. Appendix 3, the requirement is in page number 37.
Now, I have to either procure an appendix 3 from someone who has been already allotted the land by the forest department. And accordingly, I submitted in the form of appendix 3 an affidavit by one of the allottees who was already allotted the land. That affidavit I have submitted, that is at page 125. That affidavit I had submitted in the pro forma of appendix 3. That I have annexed here as well at page number 125. This was by one of the allottees under the forest department. So I was under the impression that if I enter into an agreement with such an allottee, this would suffice the requirement under appendix 3, and I would be under the group 2. I will be considered for selection under group 2 category. Now comes an email after this. That communication, your lordship will kindly see.
But, there's a but, big but. The but is, can you have a long-term lease?
No, I cannot. Now, thereafter, my lord, my case rests on, my lord, my pair before the authorities thereafter. What happened was, initially, I submitted my documents, including this appendix 3 pro forma, and thereafter, there was a draw of lot in which I was intimated that I have been selected, and I was asked to re-upload those documents which I had already submitted along with my application form once again, along with deposit of security deposit and all, which also I did. Thereafter, a communication comes on 23rd January, that is at page 141.
50,000.
40,000 and 8,000, 48,000. Now, thereafter, at page 131, the communication comes first that there is some rectification required to be made on my part. At page number 131, your lordship will kindly see, you are requested to upload the following rectified correct document by 13th February. They stipulated a time frame. To upload rectified correct documents, click here and so. What are the documents I was required to rectify and upload, re-upload? The main thing was at serial number 5. These are the others are corollaries. The serial number 5, appendix 3 for offer of land to be eligible under group 2, if applicable. Please note that such consent letter in the form of affidavit, that is appendix 3, should have been tendered by the owner of the offered land on or before the date of your application. And the reason cited is also the fifth one, dotted fifth one, appendix 3 from Mrs. So-and-so is taken who is not the landowner. Understandably, she is not the landowner. Now, to that, my lord, I preferred a representation before the forest department, the concerned authority of that particular area, that is at page 132, whereby I requested narrating the sequence of events and the requirement that that was there. I made a request before the concerned forest department official to allot suitable land within that particular locality, because the advertised area, the entire area is under the forest department. The entire
No, then you will come under group 3.
My lord?
You cannot come under group 2 then. If you want a particular plot of land
My lord.
to be given to you, means you are giving up your claim in respect to group 2.
No, in regard
Yes,
to
because group 3 are those persons who do not have a plot of land,
yes,
and he will provide a land within a period of 3 months.
yes.
So you come under group 3 then.
No, group 3, my lord, applicants who have not offered land in the application, only applicable for locations under SC ST category. Here is not this this advertisement was not for SC ST, it was open category for physically handicapped candidates. So this group 3 in my understanding would perhaps not be applicable for me. Group 2 basically is applicants having farm offer for a suitable piece of land for purchase or long-term lease. So I would have gone in for a long-term lease with someone who is the owner of that land.
But you
So-
don't have.
I don't have. So group 2 basically envisages the provision for those who do not have land, but who can offer a long-term lease for a period of 19 years, 11 months with the original owner of the land. But here is a situation, my lord, where the entire area that has been advertised is a forest land. So to
So
have,
it is for the benefit of the forest people.
yes.
So
And-
why are you coming?
No, that has been advertised, my lord.
Understood. So why you are coming? You don't have a land, you cannot get a land.
No, I cannot get a.
So
But my
what
lord,
is your case?
my lord, since this area was advertised,
So they
And
cannot,
I-
they may not get, they may change the terms and conditions. But you don't get a right if you don't have a land or you are not in a position to get a land.
but I can procure an appendix 3 from forest department
Regarding
regarding my allotment
how will the appendix 3 is to be given by a co-owner
or owner
or a owner?
or owner.
No, it is being given by whom? Why will the forest department give you an appendix 3?
My lord, that is why I made a representation before.
They
the
have
forest department.
rejected.
No, they
Right.
haven't. They haven't come up with
Okay,
any.
let me reject it on their behalf. Matter over. Yes, Mr. Chaudhary.
This is instructions, my lord, that he could not, my lord, give the document time.
Huh?
He could not, my lord,
Produce it matter over. What is there?
and that rejection was in April 2024.
April 2024 otherwise looks very fresh for this court, taking into account that this court is on everyday basis taking up non-payment of dues, where people are asking dues for the year 2013. So 2024 is too very recent.
My lord,
Dismiss.
security deposit. My lord,
I will get back.
my lord, one observation at the end after this.
Huh?
After dismissal, one observation at
That what?
towards the end. My lord.
He will say, I will record his submission that you want to take the security deposit, you can
Well.
apply and he will get it back.
My-
Heard Mr. D. Chakravarti, the learned counsel appearing on behalf of the petitioner. Mr. M. K. Chaudhary, the learned senior counsel, assisted by M. Sharma, appears on behalf of the respondent numbers 1, 2, and 3. Mr. D. Gogoi appears on behalf of the respondent number 4 and 5. The present writ petition has been filed assailing from an email dated 17/4/2024 issued by the respondent number 3, whereby the petitioner was directed, petitioner was asked, whereby the petitioner was informed that the candidature of the petitioner for the retail outlet dealership within 5 kilometers from Bilaipur MPHC hospital towards Lala on Goglasera, Bilaipur Road, district, Hailakandi was cancelled. And further, seeking direction that the forest department to the respondent number 5 should expedite the process for allotment of land in the name of the petitioner. First, for the purpose of deciding the inputs of this court, taking into account the issue involved, takes up the writ petition for disposal at the motion stage itself. It appears from the records that the Indian Oil Corporation had issued a notice for appointment of regular/rural retail outlet petrol pump dealership. And such advertisement was published on 28th of June 2023 in the English daily, the Assam Tribune. The location in question is, which one?
Page 30, serial 345.
Is at serial 345 of the notice inviting tender. That is within 5 kilometers from Bilaipur MPHC hospital towards Lala town on Goglachera Bilaipur Road. It is further seen that the said retail outlet was specifically reserved for SC Reserved for SC only.
My lord, here it is showing SC, but in the communication it was shown as PH.
No, this is
Yes, here it is showing as SC.
SC. And where you an SC?
No,
Then matter over there itself. The petitioner, pursuant to the said advertisement, submitted the application. Where is your application?
application at page 119.
On
17/10/2020.
17/10/2023. Claiming that the petitioner fell within the group 2 category. And in that respect, have placed reliance upon a plot of land belonging to one Gina Bormon, Jeena, Gina Bormon. And on the basis of, what is that?
That appendix 3 affidavit, my lord. That I have annexed at page 125.
On the basis of an affidavit submitted by Srimati Gina Bormon, wherein it was mentioned that the said plot of land that wherein it was mentioned that in case the petitioner is selected for RO dealership, she will either sell, transfer, lease the aforesaid the plot of land to oil company or to the petitioner for setting up of the retail outlet facility in the said location. It is further seen from the materials on record that a draw of lots was held by the respondent IOCL authorities amongst the applicants coming within the ambit of Group 2. And the petitioner herein was selected, was provisionally selected. Thereupon, the petitioner duly submitted the security deposit. What is that security deposit?
130, yes, security deposit. 130, 13.
On the basis of the communication dated 12/12/2023 to the tune of rupees 40,000. At the time of verification, the petitioner was further informed that the documents of the petitioner would be verified. Upon verification, a communication was issued on 23/1/2024 to provide rectified correct documents by 13/2/2024. The various documents for the rectification was sought to various documents as mentioned in the said email dated 23/1/2024, and the reasons were also duly mentioned. Taking into account the relevance of the said email, this court finds it relevant to quote the relevant portion of the said email. Hereinanda. এইখন ইমেইলখন ক'ত কৰি বুজিছে নাই ওপৰকো নালাগে এই মই টিকটো দি দিছো টু শাহ আলম লস্কৰৰ পৰা এই ৰেছপণ্ডে এইখিনি পেজ 130. From the above quoted email, it would be seen that there were various defects pointed out in the bid so submitted by the petitioner. Amongst the defects relevant for the purpose of the instant dispute is that the copy of the land documents which were submitted by the petitioner was on non-alienable land which could not be leased oblique, which could not be given on long-term lease. It was also mentioned that the appendix Roman 3, which was submitted from Miss Gina Borman, could not have been submitted as she was not the landowner. The petitioner, on coming to learn about the said communication dated 23/1/2000, email dated 23/1/2024, submitted a representation to the divisional forest officer on 24/1/2024, urging the divisional forest officer for allotment of suitable land to the petitioner within 5 kilometers from Bilaipur MPHC hospital towards Lala on Golsala, Bilaipur Road, for the purpose of setting up retail outlet dealership under IOCL. However, the respondent authorities in the forest department did not consider the representation, resulting in the cancellation of the bid so submitted by the petitioner by the impugned email dated 17/4/2024. The petitioner thereupon submitted a representation on 24/9/2025 and immediately the petitioner thereupon, the records do not reveal that the petitioner thereupon took any action immediately, but rather submitted a representation on 24/9/2025. Subsequent thereto, as no response was given to the representation dated 24/9/2025, the petitioner is before this court. Mr. M.K. Chaudhary, the learned senior counsel representing the respondent numbers 1, 2, and 3, submitted that the impute of email issued on 17/4/2024 ought not to be interfered with, taking into account that the petitioner did not submit Appendix Roman 5 as per format, semicolon, did not submit Appendix Roman 3 from the landowner, bracket, which in this case is the forest department, bracket close, semicolon. No clarification was received from the petitioner regarding land document. And further, the petitioner had requested additional time, but the policy of the respondents does not permit the same. This court duly heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. It is very pertinent to take note of that clause 4 of the brochure for selection of dealers for regular and rural retail outlets, June 2023, hereinafter referred to as the brochure, stipulates the eligibility criteria for individual applicants, there's proprietorship/partnership. Clause Roman 6 of, and the subclause Roman 6 of clause 4 of the brochure refers to the land. It is seen from a perusal of subclause Roman 6 that the applicants have been classified into 3 different categories depending on the land so offered. Group 1 category are those applicants having suitable piece of land in the advertised location /area, either by way of ownership /long-term lease for a period of minimum 19 years, 11 months, or as advertised by the OMC. Group 2 are those applicants having term offer for a suitable piece of land for purchase or long-term lease for a period of minimum 19 years, 11 months, or as advertised by the OMC. And group 3 are those applicants who have not offered the land in the application. And such. It is also relevant to observe that group 3 would be only applicable for locations advertised under SC/ST category. From the materials on record, it would be apparently clear that the petitioner neither has a suitable piece of land in the advertised location, nor had a long-term lease for a period of minimum 19 years, 11 months, which is the requirement to come within the ambit of Group 1. It is further. Now let this court take note of as to whether the petitioner would come within the ambit of Group 2. For coming within the ambit of the Group 2, the petitioner ought to have a firm offer for a suitable piece of land for purchase or long-term lease for a period of minimum 19 years, 11 months. It is the admitted case of the petitioner, as would be very much apparent from the representation submitted by the petitioner to the divisional forest officer, that the petitioner did not have a firm offer from the owner on the date on which this application was submitted. It is in that view of the matter, the petitioner cannot and ought not to have been brought within the ambit of Group 2. The respondent authorities have duly taken note of the same, as would be apparent from the email dated 23/1/2024, which have been quoted herein above. And in the further opinion of the court, the respondent authorities have also rightly rejected the candidature of the petitioner in the Group 2 category, inasmuch as the petitioner admittedly did not have a plot of land, have a firm offer from the owner of the land, as on the last date of submission of the form. Considering the above, this court does not therefore find any good ground for interference. Before parting with the record, this court, however, finds it very pertinent to observe and to take note of a submission so made by Mr. D. Chakraborty, the learned counsel appearing on behalf of the petitioner, that the petitioner ought to be refunded back the security deposit. Mr. M.K. Chaudhary, the learned counsel, senior counsel, representing the respondent numbers 1, 2, and 3, submits that the respondent authorities have is not adverse to returning back this.
If I may point out, I have gone through, there is a forfeiture clause because he has deposited 10% of the security amount. If your lordship kindly comes to page 63, my lord, there is a forfeiture clause. Page 63, my lord. Clause 20 is security deposit or an initial security deposit. If your lordship comes to, my lord, 10% he has to give as initial. Then, my lord, those bullet points, my lord, the first one, where the provisionally selected candidate fails to submit required certificates, documents, rectified documents within the stipulated time. Forfeiture clause is there.
Before parting, cancel. You have come for getting the security deposit.
No.
Otherwise, you have no business of filing the writ petition.
Well, apply.
Item 5,
But before parting to Dokarnai, huh? Accordingly, writ petition stands. Yes, Mr. Sharma.
Well, it relates to the settlement of Baganpur market, the Dhamdhama development block. The petitioner, he was the highest bidder, but settlement was made to the fourth bidder, my lord. The first bidder, he has given the bank up, where his name was not recorded by the banking authority, my lord. Thereafter, when the settlement was not made to him, he has made inquiry. Then respondent authority has returned the bank up to him to get his name recorded in the bank up, my lord. So accordingly, after getting his name recorded, he has resubmitted it, but settlement was already made to the respondent number 4, who is the fourth bidder, my lord. So Annexure 5 is the statement and 3 is the comparative statement, my lord. Annexure 3, page 34. Pradeep Busumutari, he has offered 2,04,000 or 20,000. Again, the official bid money 1,33,000. And the present bidder, settlement holder, has offered 1,35,000.
But why have you approached so late?
Yes.
Why have you approached so late? This was done when? When was this done?
No, we have,
Huh?
we have,
And then for 1 year, almost 6 months is over.
under 6 months, he will get, my lord.
Absolutely no. By the time the matter finishes, your writ petition, you come back and say that my writ petition has become infructuous.
No, he is late because, my lord, the respondent.
You were waiting for this court to pass that order. You were waiting for that. For those three matters.
Yeah.
You are waiting for that order and thereafter you are approaching this court.
No, that is the.
Isn't it, Ms.
he
Mora?
was returned the check, my lord, during that.
Huh?
After, when the bank was returned to him, after getting his name recorded from the banking authority, he has resubmitted it. The authority has centralized him that, well, we will make settlement in his name. But it was not made. That is why we were a bit late in filing the petition, my lord.
Regarding the bank draft from the earlier occasion.
Well, I know that. That is what I'm saying. He has approached this court. That is why he has filed after the order passed by this court on 24/10. He must have got hold of these people. Will issue notice, let us see. I don't mind it. A 1 year contract, if you approach after almost 6 months, what is this point? Issue notice making it returnable on 24th of November 2025. Steps be taken, Miss. Who is appearing for the BTC? Miss Ardas accepts notice on behalf of the respondent number. Now, Miss Anbora accepts notice on behalf of the respondent number 1. Miss Arda accepts notice on behalf one. Miss Arda accepts notice on behalf of respondent number 2, 3, 5. Miss Yuda, the learned petitioner senior government advocate, accepts notice on behalf of the respondent number 4. Extra copies of the writ petition be furnished to them within 3 weeks, by tomorrow. As regards the respondent number 6, steps be taken by way of speed post. By tomorrow, liberty given to the petitioner to effect service upon the respondent number 6 by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein had participated in the bid for Baganpara Weekly Market pursuant to the notice inviting tender dated 8/5/2025. It is the case of the petitioner that the petitioner was the highest bidder. However, the respondents have issued the bid, have said made the settlement in favor of the private respondent number 6. By an approval dated 15/7/2025. Taking into account that the petitioner has approached this court by filing the present writ petition only on 22/10/2025, this court is not inclined to pass any interim order at this stage without getting the instructions from the respondent authorities, more particularly the BTC.
We'll make
List
justice, that may be fixed every day ahead.
What?
That may be fixed every day ahead, we'll make justice. That may be fixed every day ahead of 24, we'll make justice.
Today is what?
Please start.
20, 19, 20. Like.
You want to make the service upon respondent number 6.
I will make justice.
I've given you. Okay, 21st.
Supplementary item 43.
What is this, Mr. Monta?
My lord. My lord, the petitioner before your lordship is the City Bus Owners Association plying their buses in the roads of the city.
What is wrong?
Firstly, that these two routes, particularly here,
Anapara to Dharapur via Ganeshguri flyover,
and
Krishna Mandi to Dharapur versus Polton Bazaar.
hold on, Buddha, this route number 36. Our buses are plying in these routes also, besides the other routes. Those are continuing. Meanwhile, they tried to oust us. 200 buses were off-roaded. We approached this honorable court. This honorable court stayed it. And thereupon, they allowed us and it was continuing. Now, they say that we are going to make these two routes green route. And therefore, only electric vehicles at the behest of some private players would be plied on that to the exclusion of your bus. Whether this is permissible without reserving, without making specific notification, without going through the procedure prescribed under the law, whether they can do it. They have, meanwhile, taken
They can
forward.
do it now also.
They can do it. They can do it provided.
Your time is there till 31/12.
No, Malad, they have not done it. They have meanwhile declared it. That from
Declaring is nothing to that, but it will be done. It will only come into effect from 1/1/2026.
1 yes, that is what
So
they
as
say.
of now, there is nothing.
As of now, we are apprehending only that they are going to take. And what is the difficulty?
They won't renew it.
They are not renewing it.
But you are now pointing out that they can renew it. They can still continue do it by issuance of a notification.
No, that, if there is reasons to do that,
I have received instruction, my lord, page 5, technical course of action, Lordship. I have page it.
Anyway, this is a case for issuance of notice. Let them file affidavit. We have time.
Lordship, may please
because
get the-
now, Malad, at the moment, what they are doing,
Here, what is the course of action? Madam, as per the edition and directive issued by the RTA in its meeting held on Iman, upon approval of the feasibility report to be submitted by the DPA, 1 month notice shall be served to the remaining bus owners, providing them an opportunity to reroute the vehicle on a first come, first basis, subject to the availability of the route. Moreover, it is also considered appropriate that notices to the concerned bus owners be delivered to door visit. It is further clarified that no permit shall be suspended or cancelled under the green route resolution. Only the routes shall be allocated or changed in accordance with the provisions of so and so.
Yes.
They are going to take it.
what does it say?
Let them file affidavit.
Yes, Lordship, I'll bring the record.
Because, Malad, for the time being,
No
our,
stay.
sorry, no, question is,
No stay.
Malad,
How can they stay something which is not born, which is yet to be born?
Malad, I'm not on that. I am on the affected action taken as on this.
No. Let
No,
if
no.
they were,
What they are
if
doing-
they are going to do it, they are going to take steps. I can do one thing. I can dismiss your requisition on the basis of this instruction. The division bench is you have very kind judges. They may give you some order, but I'm not going to give you that.
No, my lordship will kindly.
You
listen
want
to
the
me.
disposal? I can give you the disposal
no,
right
Malad-
way, Mr. Mohta. I can give you a
Malad,
disposal right
lordship
way.
will kindly bear with me for
No,
2 minutes.
No,
They are
I
what they are
may
doing now.
only- The most I can do is ask them to file their affidavit.
Yes, Lordship.
No,
I'll do
that they will do, lordship will ask them. But at the moment, what they are doing is, they have my license are certain, like the permits of certain buses are expiring. So under the law, they have to extend it. They have to extend it. They are extending only on 6 months basis, which is also not supported by law. And they take the fee for the 5 years. Fee fixed for 5 years. They are charging it, but extending only for 6 months. That is, they have admitted that this is an anomaly.
As of now, is it expiring today?
Few have expired and they have extended only on 6 monthly basis.
So 6
Taking-
months basis, they have extended. So as of now, it is life.
Well, as of now, those
They are
are
like-
extended. Those are extended, but charging 5 years charge.
So you'll have a right to get refund.
That part-
Under process, my lordship.
That
We'll
part,
take up the
But that
video
is
and
not your
access.
case.
No, that
Your
is also
case
my
is,
case.
no, Mr., your case out here as per.
that they should
sheet
not
of the
realize it in that,
No,
they
no,
should not
why?
realize
There
it.
should not be issued directing respondents to
Yes.
recall receipt
And-
or forbear from giving effect to the impugned resolution and further direct them to renew the permits of the buses for a statutory
Huh?
period and declare the renewal period. To direct the respondent to allow the city buses to ply in the designated route and not to house the courier. This is your prayer.
Yes, and also,
And
Can you-
also what?
go down little, there are respondents to renew the permits of the buses for the statutory period and to
What is the
declare
statutory period?
5 years,
5 years.
5 years.
1 year to 5 year. Where is
5
it?
years.
Lordship, 40.
Show me your last renewal.
The model. Hmm. Our license is
And
permit.
it's a-
Let us come to Mr. Monto, kindly come to page 78.
page
78.
70.
Period of validity 25 January to 2024 to 24 January 2029.
Yes,
Then
those are there. Some buses are there because we
Then
have so many
all,
buses.
all these are there till 2027.
Yes,
All
sir.
these documents which you have enclosed.
These are,
I
we have
think,
shown that this
You
bus,
need to take the recourse to the division bench.
this,
Better.
now, Malad,
No, I think you need to take the recourse to the.
these buses, those who have their license beyond
The policy decision of
20,
the government,
25.
what is wrong?
25 days, no problem.
No.
But in respect of other buses,
No, some kind judges
those,
passing some orders.
Malad, buses whose permits have meanwhile expired, it is admitted by them that yes, this was an anomaly. They should not do it. Kindly see their own findings.
In fact, Lordship, on last page,
Page 83, Lordship will find.
Where?
At page 83, they have said in their minutes of the RTA board's meeting, regional board, addressing the issue, last paragraph, page 83, addressing the issue of non-reciprocal permit fees, whereas 6-month stage carriers permit cost rupees 2150, while 5-year permit cost only 3150. The Honorable Chairman directed the DTO and Secretary RTA Board, Metro, to report this anomaly to the Commissioner of Transport in order to ensure financial fairness for bus owners. So we protested that you please don't do it. You cannot do it.
Which one?
This permit fees realized at a disproportionate rate and only from issuing extension for 6 months. Minimum 1 to 5 years. This should extend.
regarding that page 2 of my instruction, Lordship, it's under process, madam.
Okay. I'll issue a notice. You file your affidavit.
Lordship, it is a short date, my lord, that on last date, on next day, Lordship may dispose of this matter. I will be.
I won't dispose of, let's see. I'll
Let them file, yes.
In one.
I- Issue notice making it returnable on how much time?
10 days time.
Making it returnable on 19th, on 21st of November 2025. Miss MD Bora accepts notice on behalf of all the respondents.
1, 3, 4 is message.
What is who?
4 is a deceived chairman, RT.
What is this? You are 1, 2, 3, and Miss so accepts notice on behalf of the respondent. Extra copies of the petition will be furnished to the learned councils representing the respondents during the course of the day. The petitioners herein, which is an association of bus owners of Guwahati, are aggrieved by the proposed actions are aggrieved by the decisions so taken in the minutes of the meeting dated 5/4/2025 and 5/7/2025, whereby it has been decided that the state carriage permits of buses operating in Route 23, bracket Khanapara to Dharapur via Ganeshguri flyover, and Route 36, bracket Bokhisto Mandir to Dharapur via Polton Bazar, shall not be renewed beyond 31/12/2025 on the ground that the state government would be introducing more electric buses in the said route, would be introducing electric buses. There's no more
Yes,
electric buses
CNC.
on the said route, and the said route would be green routes.
Sure.
So, Mr. K.K. Mohanto, the learned senior counsel appearing on behalf of the petitioner, submitted that such a move is not permissible, taking into account that without necessary notifications being issued, the respondent notifications under the Motor Vehicles Act
Act.
1988 and the rules framed therein under issue, such action on the part of the respondents is not permissible. He therefore submits that the impugned decisions so taken in the minutes of the meeting held on 5/4/2025 and 5/7/2025 ought to be stayed pending notice. This would have also heard Ms. M. Deborah, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3, who submitted that within 10 days the affidavit would be filed. This court further takes note of that the impugned decisions taken in the minutes of the meeting held on 5/4/2025 and 5/7/2025 would only be effective with effect from 1/1/2026. And as such, without permitting the respondents to bring on record their stand, it would not be in the interest of justice to pass interim directions. Accordingly, the respondents shall file the affidavit on or before 13th of November 2025. Liberty given to the petitioner to file the reply on or before the next date.
Lordship, can you fix that matter at 2 on 21st?
Why?
Lordship, I don't
Ah.
accidentally.
Anyway, I'm here
Apply.
till 30. You take your instructions.
I'm so deeply obliged, Lordship.
For admission item 6,
Arveta line लिखी हुई होता है, that question whether there is a necessity for passing interim direction shall be considered on the next. Yes, what is this? B. Chaudhary has informed about the assessment to be made in respect to the compensation payable by the district commissioner Tirang with the department directly. Please.
The assessment has been made, Manas. We received the communication on 31st October, Manas. The amount has been calculated. The payment will be made within this week, Manas.
Within?
Within this week.
It has been served. It has been submitted by Mr. B. Chaudhary, the learned counsel appearing on behalf of the respondent APDCL, that the assessment have been duly made by the district commissioner,
Manas. Through the circle officer.
Sira, to the circle officer of the concerned revenue circle. And the payment to the petitioner would be made within a period, within this week itself. In that regard, and instructions have been placed before this court, which is kept on record and marked with the letter Y. Taking into account the above, list this matter again on 12th of November, the 14th of November, 2025. 14th, I won't be there. 12th of November, 2025 for an update. 1 week. After this, you have to approach 16. Tell your clients in the meantime.
My lord,
Yes.
matter pertains to non-payment of contractual bill, my lord.
We have received instruction, we are disputing his claim, your lordship. We are disputing his claim.
Disputing?
Yes, because the petitioner has not submitted any challan for payment, your lordship. The procedure which we need.
Here, executive engineer has given.
I have the written instruction, your lordship.
Who has given the liability statement? Where is the liability statement? Yes, Mr. Counsel, liability statement where? Member Secretary, DWSC come executive engineer. Yes, again I told you, the executive engineer PHE is going to do something. So what has not been done? Where is the completion certificate?
My lord, as per my lord, confirmation of the bills, my lord, we have submitted the bills, my lord, accordingly. Page 51, my lord, kindly peruse. This
Yeah.
is the regularization of work orders, my lord.
Okay, you have got instruction, bring it on record by filing.
We'll file
Mr.
it,
R.
right?
Gogoi, appearing on behalf of the respondent PHE department, submits that the respondent PHE, that the respondent department disputes the claim of the petitioner. So it is the opinion of this court that if the respondent authorities dispute such claim, the same be brought on record by filing affidavit, so that the petitioner can be afforded an opportunity to submit a reply. The learned counsel, Mr. Gogoi for PHE department submits that the affidavit will be filed within
Within a week, your lordship.
within a week. Considering the above, list this matter on 26th of November 2025. The affidavit be filed on or before 17th of November 2025. Liberty given to the petitioner to file reply on or before the next.
My lord, deeply obliged.
8,
Mr. Ghosh, where is he? He expressed urgency in the matter, he is nowhere there. Hello. What is this matter?
Cancellation of the license.
Lordship, my senior is on legs only, lordship.
Okay, we have it after vacations. Let your senior do the matter whenever he feels like.
Lordship.
Yes, Mr. Ghosh.
My lord, in this case, my lord, it is the second round of litigation, my lord.
So, well, let us make it the third.
My lord,
Yes. Tell me, what is your case?
my lord, in this case, my lord,
The
actually, our
license have been cancelled.
license has been cancelled, my
What
lord.
is the reason?
Reason, my lord, will kindly see the cryptic order, my lord. That I will take my lord to this order.
Where?
At page 64, my lord.
For?
Yes, my.
Where is as per the provisions of the personal here?
What is the order? 5 cases has been taken together, my lord.
FPS, 2 FPS, namely, date of period of date of the delinquent site. Now, after putting that guy.
Yes.
What is this type of order? You have any other order apart from this for cancellation?
Their affidavit said nothing.
No, come on. You set aside it and ask you to do it in reason. Don't you think reasons are necessary?
Yes. Result has to be there, Lord.
Is it there? Yes. Kindly help both of you together. There are how many petitioners here?
2, my lord.
Oh, then you have to give up the right of one. How can you have file two writ petitions having both having separate cause of action? Does the petitioner number one has a cause of action as regards the in respect to the fair price shop of the petition number two? Is it there?
Lordship may condone this.
Huh?
May condone this, my lord. because
condone?
the man, my-
10,000 cost upon the council for filing two writ petitions, two persons, one writ petition and let it go to the lawyer's part. You are doing some help. Just give it. If you want, otherwise I give up only one. What do you want? Either pay that cost. Or choose amongst the petitioner number one and two, who is it? There cannot be a same cause of action. Can there be a same cause of, can the petitioner one be aggrieved by the cancellation of the license of the petitioner number two?
My lord, no, I respectfully agree with my lord. I
So
respectly
you-
agree with my.
So therefore you
My lord,
deposit the cost of
this-
10,000.
My lord, this, when this beef was come to me, I pointed it to my lord.
You
This is
pointed
the
it out, then-
problem, My lord, then.
So 10,000?
No, my lord.
Before cancellation,
Huh?
before cancellation, they were asked to present in their hearing.
No, I am not selling. I am, you have suspended. It will now come up. We set aside the cancellation and put them under suspension.
Already, they are.
And you have to decide within the 30 days
Lordship.
and give due reasons.
And 90 days period is already over, my lord, that there, when they issued a suspension order, since then, they did not pass any order within 90 days.
No.
My lord, when we approve this honorable court, then they present this order, my lord, that we have cancelled.
This order is being passed, but the fact remains, if I allow you to run today on the basis of, without going into the merits, I'm not going to go to the, I'm going on the ground of principles of natural justice being violated.
Lordship.
How can I allow you to run? Tell me, give me a very good reason.
My lord, I
I
said,
will allow you to run.
because of that, my lord,
No, it will be suspended. Be under suspension for a period of 30 days. If they don't pass an order, reasoned order, then they will be, and they will have to lift your suspension. The
Otherwise,
suspension
understood,
shall no longer,
understood, lordship.
but this is subject to 10,000 rupees to be deposited by Mr. B.J. Ghosh to the High Court. Before the registry shall proceed to the High Court.
I will leave it to your kind
We
consideration.
impose the
my lord.
cost.
My,
Because once I do this, it will be a precedent in all future cases. Because in all other cases, when it is a motion, I permit only the first writ petitioner, and second, I grant the leave for the other three.
no, you don't know, you don't know. He has not understood.
So we choose one of the petitioner. Let me keep my precedent. Which petitioner do you like?
My lord, I'm not-
Huh?
It's difficult to make the option, my
Okay,
lord.
I'm rising now. Come back at 12. You take the choice of any of them, call them any of one of the petitioners. Because they made the mistake of filing together.
It's a bona fide mistake, my lord.
Or if you want this court to passing remarks against you or the filing council for doing all this mischief, I can do at your cost. Reprimanding your conduct for doing two matters together. Either you want to think about your client, you want to think about yourself, you can have it.
Many thinkings, many thinkings. Lord.
Yeah.
My lord.
Or should you have it after vacation?
My lord, may it is.
Let us have it after the winter vacation.
Lordship.
You may have the opportunity of thinking so much.
My lord, can it be so far?
It is only after the winter vacations you may get a good judge who may consider to it without reprimanding. After vacation?
Lordship, may I, well, subject to lordship correction, my lord.
Yes.
May I, my lord, if a lordship is inclined grant only with respect of the one petitioner, my lord. So for other petitioner is concerned, let me allow to withdraw and my lord file a.
That is what I do.
a Petition on the same, because that order, lordship order will cover that also in my humble submission.
No.
But-
For that again notice will go.
Let the notice go.
This
but
is of
my lord-
2023, we are finishing in 2025.
Lordship.
So that person will again lose for another 2 years. It will
Under-
be in 2027. Then, or you want to wait till January? Till 19th of January 2025, from 28th of December 2025, there is only 5 working days. To them. Tell me. Think, I'm coming back in 5 minutes.
Instruction of my lord, then so far petitioner number 1 is concerned, my lord. And so far petitioner number 2 is my lord concerned, my lord. She may kindly guarantee to liberty to withdraw it and file a, so far 2 is concerned, we will leave it. I,
Finally come to page 60. Yeah. Read the prayer.
yes, my lord. We beg to inform that the license under circumstances, you are kindly enough to consider a fair and take, when to withdraw our fair by shop license, it will be a suspension, my lord. It will be suspension. But no remedial action has been taken. That is the thing. Because if a lordship look into this,
I understand, but what is your prayer?
that is mistake, my lord. I've gone through, my lord. Yes.
What is your prayer? That the license should be withdrawn.
Suspension today means suspension, my lord. They are, my lord. Today they are like,
Mr. B.K. Ghosh, the learned counsel, appeared. Mr. S.R. Bulbai appeared on behalf of the respondent. All the respondents?
All the.
Both the petitioners. Herein are Fair Price owner, Fair Price shop owner, license. Granted under the provisions of the Assam Public Distribution of Articles Order 1982. Short the order of 1982. On the ground that on the basis of a report of the superintendent, FCS NCA, Lokipur, Kachar, wherein it has been alleged that the petitioner number one lifted NFSA rights for the month of June 2023 on 4/5/2023, but did not distribute the entire quantity till 8/6/2023 after a gap of more than 30 days. And further, the petitioner number one and further, as there was shortage of 7 quintals of rice found in the available stock of the petitioner number one in the petitioner number one sales register. And for various other reasons and also both the petitioners have assailed the order dated 6/11/2023 in the instant petition. The materials on record show that the superintendent, FCS NCA, Lokipur, Kachar, had submitted a report to the superintendent, Food Civil Supplies NCA, Lokipur, wherein it was alleged that the petitioner number one had committed the following violations. A, lifted NFSA rice for the month of June 2023 on 4/5/2023, but did not distribute the entire quantity till 8/6/2023 after a gap of more than 30 days. B, more than 7 quintals of rice found shortage in available stock compared to the sale register compared with the sale register. C, the petition number one did not display stock and price board of the FP shop. D, the petition number one did not maintain stock register of allotted articles. E, the petition number one did not hang the beneficiary list in the fair price shop. F, monthly performance report not submitted by the petitioner number one. And G, the available stock of rice did not tally with the sale register. In view of the sale, allegations contained in the report, it was prima facie found that the petitioner number one contravened clause 10, 14, 18, 20, 21 of the order of 1982. And accordingly, the superintendent Food, Civil Supplies and CA, Lakshmipur, that is the respondent number 5, had suspended the license of the petitioner, number 1, by an order dated 15/6/2023, and further show cause the petitioner number 1 as to why the license should not be cancelled. The record further revealed that in respect to the petitioner number 2, the report so submitted alleged that the petitioner number 2 had committed the various infractions. A, received allotted quantity for the month of June 2023 on 5/6/2023. And did not distribute to the consumers till 8/6/2023. Whereas other dealers lifted rice in the first week of May 2023. B, the petitioner number 2 did not hang the beneficiary list in the FP shop. C, the monthly performance report was not submitted by the petitioner number 2. It was therefore found, prima facie opined, that the petitioner number 2 contravened clauses 10, 14, 20, 21 of the order of 1982, as well as also violated clause 4581 of the terms and conditions of the dealing license issued under the Act of Order of 1982. It was under such circumstances the petitioner number 2 was also suspended by an order dated 15/6/2023. Was suspended by the order dated 15/6/2023, and the petition number 2 was also show cause as to why the license should not be cancelled. The record reveals that the petitioner thereupon submitted the replies and sought for withdrawal of the suspension by separate communications. It is also seen from the records that both the petitioners filed the writ petition, being WPC number 6410/2023, challenging the continued suspension of the licenses of the petitioner. Upon filing of the said writ petition, the said writ petition, however, was withdrawn, taking into account that the respondent number 4 have issued the order, impugn order dated 6/11/2023. It is under such circumstances the present writ petition has been filed assailing the order dated 6/11/2023. Mr. B.K. Ghosh, the learned counsel appearing on behalf of the petitioner, submits that the principles of natural justice, which is a facet of Article 14 and 21 of the Constitution, mandate that when an authority takes any action against a licensee, mandate that the principles of natural justice, the B.K. Ghosh, the learned counsel appearing on behalf of the petitioner, submit that Article 20, that the principles of natural justice are facets under Article 14 and 21 of the Constitution. The principles of natural justice not only includes issuance of notice, but also mandates that when an authority takes any action resulting in civil consequences, there is a requirement of passing orders containing reasons. It is also submitted that if no reasons are being assigned, the order would not only be in violation of Article 14, violation of the principles of natural justice, but also becomes unreasonable and arbitrary and in violation of Article 14 of the Constitution. Mr. S.R. Barua, the learned counsel appearing on behalf of the respondents, however, submits that though the order dated 6/11/2023 does not contain any reasons, but it would be seen from the very show cause notice itself that there are various, that the petitioners, both the petitioners have infringed the various clauses of the order of 1982. And as such, the reasons mentioned in the show cause notices can be read into the order dated 6/11/2023. This would have duly heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. From the perusal of the materials on record, it is seen materials on record, and more particularly the impugned order dated 6/11/2023, it is seen that the said impugned order, though cancels the license of the petitioner, both the petitioner, but there is no reasons assigned. Merely, it has been mentioned that personal hearing was afforded, and thereupon certain incriminating materials were found for which the license had been cancelled. The order, in the opinion of the court, order dated 6/11/2023, in the opinion of the court, is bereft of any reasons and also is vague. It is the further opinion of the court that when the state takes action, reasons, it is further the opinion of the court that when an authority makes inquiry on the basis of a show cause proceedings, the inquiry exercises jurisdiction in the capacity of a quasi-judicial authority. And as such, the reasons, and as such, the order so passed has to contain reasons. Nothing has been mentioned in the said order, impugned order, that what were the incriminating materials and what was the infringement found on the part of the respondents, which requires the cancellation of the license. Under such circumstances, it is therefore the opinion of the court that the impugned order dated 6/11/2023 is not only in violation to the principles of natural justice, but also is unfair, unreasonable, and arbitrary, and therefore requires interference. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The impugned order dated 6/11/2023 is set aside and quashed. Number two, the respondents, more particularly the respondent number 4 and 5, are given the liberty to proceed with the inquiry on the basis of which the show cause proceedings were initiated on shall be given the liberty to proceed with the inquiry and pass orders as deemed fit in the facts and circumstances of each case, each of the petitioner. It is observed that in the circumstance, the concerned respondents are of the opinion that the petitioner's license is required to be cancelled. The said respondents shall duly provide reasons in the order. It is also seen that from 15th of June 2023, the petitioner's license have been suspended. The licenses of both the petitioners have been suspended. Considering the above, this court therefore directs the respondents, more particularly the respondent number 4 and 5, to take a decision in respect to the so-called proceedings initiated against both the petitioners within a period of 30 days from today. During this period, the petitioner's license shall continue to remain in suspension. It is, however, observed that in the circumstance, no order is passed, the respondent authority shall the suspension order, so the suspension cannot further be extended, taking into account the mandate of Rule 15, Clause 15.2 of the Order of 1982. Before parting with the record, this court, however, finds it very pertinent to observe that each of the petitioners had a separate cause of action. However, one writ petition has been filed. The question of filing one writ petition or two writ petitions is on the basis of the advice given by the council. And as such, on the ground of filing one writ petition by both on the ground that only both the petitioners joined together to file the present writ petition, this court is not inclined to non-suit the petitioners. Inasmuch as on account of the mistake committed by the council, the petitioners ought not to have been, the petitioner should not be prejudiced. Mr. B.J. Ghosh, appearing on behalf of the petitioners, submits that such mistakes shall not henceforth be repeated.
Item 9.
Order is was in respect of two petitions. Right, because other partners.
Number 4, it is clarified that the instant that the order dated 6/11/2023, impugn order, is quashed only for the petitioners and not the other 3 persons, other 3 licensees.
May it please your lordship. My lord, this is for non-payment of outstanding bill of the petitioner, my lord. My lord, kindly peruse the last order dated 28/7/2025, lordship.
Yes.
Actually, we have communicated with the district. But they, till now, they put any official are discussing as per court order dated.
Who has not?
2025.
Who has not? Who has not communicated amongst themselves?
Deputy Commissioner, South Katmara, Madagascar has.
He is not cooperating with you. Is it, madam?
My lord, India now. 1 week time or my lord, so that I can take construction and talking.
Madam, have you seen my order of 28/7? Deputy Commissioner duly admits the amount.
Yes, madam, we have that.
The Commissioner, PNRD also do not deny. Okay. But there appears to be some discrepancy or miscommunication between the Commissioner, PNRD with that of the Deputy Commissioner. In view of both of you, why the petitioner should be affected? You do one thing, provide the head of account. Head of account.
My lord,
Head of account of which one? Commissioner of whom? Any of the head of account will do. We'll attach that.
my lord,
Let salaries not go to these commissioners and all.
my lord,
Ah.
my lord,
You cannot, because you in the after my passing the order, you again got a very lenient judge who allowed it. Again, it has come back to me
we have time.
because my order is specific, 28/7. And does it take after that 4 months for you to talk amongst yourself? If it is the difficulty, we can assist this both the authorities, asking both the authorities to appear here. And we may have the meeting of minds among both the authorities in the video conferencing link.
We have time.
What do you say?
Now,
Not you. They also admit. Both of you admit.
my lord,
But the fact remains, they say that you did not provide the voucher.
not.
You say they have provided the vouchers. But why these people should not get the money?
We sent for part-time, my lord.
So let us have the meeting of minds in the video conferencing link. Huh?
Next, my lord.
Something like this.
My lord, that day, my lord, if there will not be any, my lord, outcome, then lordship will be pass order, my lord. Hearing both the, my lord. both-
No, I think something needs to be done, or I'll pass an order directing both of you to pay. And from 28/7/2025, the order which I have passed,
Right.
there will be interest at the rate of 18% per annum. And that shall be taken from the salaries of both the present commissioner as well as so and so the interest amount from the district commissioner. Then they will realize
my lord. Because the other day your lordship has passed the order.
very detailed order.
The other day your lordship has passed the order, my lord. And when I forwarded the copy, on the same day that has been.
See, things
Yes,
happen in that
yes,
manner.
this type of order.
Then they will know.
10 days maybe, after 10 days, lordship will teach the, date, my lord. So that both the directly, both the respondents, my lord.
Give an update, both of
My
you.
lord, my lord, that, my lord.
Ms. Enbora, appearing on behalf of the PNRD, has placed an communication, has placed an instruction issued by the Joint Commissioner, PNRD, wherein it has been mentioned that the respondent have issued certain communication to the district commission. South Salman or Mankasa for discussion on the matter and to arrive at a conclusion regarding the discrepancy as well as to submit proper justification information before this court. It appears that both the PNRD department as well as the district commissioner, as well as the concerned district administration, have not understood the tenor of the order dated 28/7/2025, whereby both the departments have been asked to arrive at a conclusion as to when the payment would be made to the petitioner, in as much as both the departments duly admit the petitioner the liability. Considering the above, it has been submitted by the councils appearing on behalf of the PNRT as well as the district administration that they will take effective steps and give an update before this court within 10 days. List this matter on 17th of November 2025 for an update. It is observed that if effective progress is not made in pursuance to the order dated 28/7/2025, this court shall be constrained to pass appropriate orders.
Much obliged.
I think this will help you.
Item 10.
Yes, what is Tinsukia Development Authority doing? Going on?
We have challenged, my lord, the assessment of tax, which is, my lord, we'll see on the materials and records suggests, is absolutely divorce of the act. The entire assessment was done by bypassing the section 79 of the Municipality Act, which
They will say it will be fees, huh?
We are waiting.
Don't you think that, are you saying it to be fees? Are you saying to be tax or fees? What are you saying? Is it tax or fees? Tax. So you have made the necessary notifications.
Yes.
So what is the divorce of that?
Now, what you will see that the section 79 says that there would be a committee. The approval is mandatory, headed by the deputy commission. The material of record does not suggest that there is any approval while the fixation of the taxes, holding taxes by the municipal corporation, municipal body. This is number one. Number two, section 79D says that you have to impose the holding tax. Holding tax. There is no concept of urban tax. They introduce now the urban tax. In section 79D, there are three taxes. There are three headings, in fact. One is holding.
Oh, no. You will.
Kindly see their prayer, what they are now, they are saying that approval was not taken. Their whole case was that tax enhancement was exorbitant.
Yes, yes, that's, I'm
Only that
coming.
point.
How it divorce the act, that I'm pointing out to this honorable. Because imposition of
Now
the,
we are waiting for corrigendum to come up by the state government law, for which they are claiming, in their affidavit, they are claiming 25% rebate. But that has been replaced and the new corrigendum has come. Thereafter, not taken.
Then what should I do?
that process has been going on since months together, madam. That-
We are waiting for one meeting was there. In that meeting, the decision was taken for repealing or destroying what it has done. But we are waiting for that. We are.
Where is the decision taken?
The decision was taken on 21.
Who has taken the decision?
May I apprise one fact to this effect? May I apprise? Now there is a notification, there is 3 notification. Now the initial assessment was done and the final assessment. In between, a notification dated 10/3/2023 came. Now this 10/3 notification is acted upon while assessing the tax. How it's possible to revisit the same now?
This happened in 25 August. What happened there?
Provision yet to come up. They also I talked. Cannot prove it. It cannot prove it. Be able to take out that. Because they are claiming what they are claiming, the rebate can be given to the public so that the effective increase to the final property tax shall not be more than 25% of the last property tax. But it has been decreased as per my.
Interestingly, this notification has been acted upon. Lordship, kindly have a look at page 97, their affidavit. Annexure 2, their affidavit. In the bottom, my lord, kindly have a look.
What is that?
In the page 97, annexure 2, bottom, my lord. The tax amount has kept as per government notification such and such dated 10 March 2020. This is the notification.
But you are not accepting this also, Lordship. He is not accepting this.
No, I am
Saying
not
this
there.
This is exorbitant. He is
I'm
not accepting.
I am saying the 10th notification to be complied as per the notification, all the clauses.
You do whatever you feel like, otherwise we'll take up the matter for final disposal.
Yes, my lord, that's my,
You see, the court's power is limited unless
Yeah.
it is in violation. You see, the power to increase, power to assess, is absolutely within the
Yes.
domain of the government.
domain of the,
Authority. If there is an infraction to the provisions of the act, obviously, I will interfere. Otherwise, no.
yes, that's my own.
So, but there is an interim order operating since
Yes,
long,
you-
2023.
No, Lordship, it was given
Is meanwhile, my lord,
In the-
not initiate,
not initially.
not
given,
initially. Justice Jamir has.
Not initially given.
What is that interim order?
And not to take.
Not to take any courtship action, because after the demand notice, my lord, they put during the pendency of this writ petition,
What is the coercive measure?
they are not renewing our license. Then the license was held up, etc., all this. That,
Where have you mentioned in the writ petition?
Nothing is
nothing there.
Then
the violation. of
we don't
something-
extend it. What is the interim order you have asked?
And let the matter be
Stay the
disposed, my
operation
lord.
of The notification have not been stayed.
No, I am not on that, my lord. I'm not on that.
You have.
If your
no,
lordship
then
has,
Maybe right not to take any coercive action against the petitioner by enforcing their force.
Now, my only limited prayer, my lord.
No, if you make the payment, it will be subject to outcome. You'll get the money back.
No, my only prayer, my lord.
Or it will be adjusted.
No,
You are a big body.
Yes.
You're a big body. What is the
my
problem?
only prayer is,
If
he will,
everybody can pay, why can't you?
and I am not on that, my lord. My only prayer, let the matter be disposed of. If your lordship has found that there is a violation in the settled law, lordship will interfere, otherwise not. So that matter may be taken up today, my lord. This is fixed for that. Lordship may take up the matter and dispose it. My lord. That's my only prayer, my lord. Nothing. If it is goes against us, we will make the payment.
Okay, again.
The lordship kindly have a look. Section 79. Because this is the basis, my lord, this is the guiding factor for the annual valuation of the holding.
Okay.
Now, lordship kindly have a look at 79C.
See.
C, my lord.
Yeah.
The rate of rental value per square feet shall be fixed by the board of the municipality at a meeting with prior approval of the committee mentioned under section 79A.
This is the committee.
The committee, my lord. That's the important. 79A, my lord. Subsection 5, my lord.
The committee shall consist of the deputy mayor, commissioner, executive engineer, chairman, officer of the directorate, revenue. Yeah, okay, that.
Now the record suggests, my lord, that there's no approval. This
So
public,
your therefore case is,
this is number one.
this is proportionate or has a bearing. If the rental value is increased, the
Yeah.
rate of tax will increase.
Yes.
So therefore, your basic case is that in order to apply 79C or even 79B for the purpose of increase,
Well,
it has to be done on the basis of a decision taken by a committee as mentioned in section 79A5.
Right.
And this committee have not taken such decision.
that's the record suggestion.
So that is it
Yes,
your
this
case?
is my first submission.
So that is your case.
That is my first submission. The second
Understood.
is, my
But
lord,
that is one of your case.
your honor.
There being no committee who have decided in the increase in the
Yes.
rental value.
Yes.
So the question of increase in the or revision of the rate of tax does not arise.
Yes, that's my only one.
Number
submission.
two,
Number two, my lord, lordship will kindly have a look, 79D.
yes.
The tax shall be assessed on the basis of annual rental value on the following rates. Now rates are prescribed. Roman 1, holding tax. Not less than 2.5% annual relief. This is number one. Number two is water tax, subject to provision of section 71. Now 71 says, if there was a provision of water supply in the area, then the water tax will come, otherwise not. So therefore, in our area, subject matter, my lord, the 71 this is not covered. Now 3 is latrine tax. This also subject to 72. If there is a cleaning process, etc., that also not a case herein. So light and water tax will not come. So only remain the holding tax. Now
So
they introduce,
79E is revision.
yes,
But if there is a difficulty arises in giving effect to the principle of fixation of the annual rental value, as per
The
a
state
provision of
government
this
shall
act,
have.
the state government shall
State
have
government.
the power to review the same on getting a report from the executive.
yes, this is a separate thing. This is state government.
So if there is a difficulty, the
Yeah.
state government has the power to.
Yes,
review.
madam, yes. Now they introduce, my lord, here another concept of urban tax. they imposed holding tax 3% and urban tax 3%.
Huh?
The holding tax they assessed as 3% of the annual rental,
3%.
3%. And they also introduced urban tax, which is not here.
Yeah, mentioned is an urban tax, but I think if they go by, it's a piece.
Final notification, my lord.
Page 36. Pursuant to the government notification dated.
Is that it, sir?
Yes. Yes, it's. Yes. So this is a notification by which there is a change. Yes. Increase. Has been reassessed. Yes. And it is being reassessed on the basis of some government notification.
Yes.
So therefore, it is being done under 79E. 79E.
No, no,
Kindly see
no.
page 27.
Pursuant to the government notification dated when the holding tax of the center has been reassessed and the new assessed property tax will be but the new date of- This is again done prior to, when did the government do this? What is this government notification? Page 49 of the.
Page 49.
Additional government notification is
In
lord.
continuation of the. other-
page 99.
No.
49.
Page
49.
49. 49 can't be the government
no.
notification because here they are referring to
No.
notifications.
Lordship will find page 99. And another notification is page 170.
This is our affidavit. We have.
Orders of the governor. Yes, this is it. Where is the last assessment of the holding in so and so, where some of the municipal board have assessed one tax way back in 1979. And Iman of A5 of the Iman. To section Iman under the chairmanship. It is 5 years.
In this notification, my lord,
Then,
in this notification, 79 is referred to.
Huh?
Page
it is
90.
done under 79E.
Yes.
Then,
So therefore, the 79 is Hulda Fields, my lord.
no, it all.
Yes.
Or in the- So this is being done under such supervision. So the first public notice issued on 20th of February. And this is being followed by the other one.
15, 14,
3-5. Now, what is, why are you holding tax plus urban tax? For residential Iman, holding tax is 3% and urban tax is. Now, tell me, where is the concept of urban tax?
Earlier.
Huh?
Just giving to 1975
No. Show me in the act. Where's the urban text?
That was not there, Lordship.
Then?
But it was Lordship, some urban area usual property tax 1969 was there. It was omitted now in 2022, Lordship. Like the urban tax is coming from that. It was informed.
But if you was omitted in 2022, then how did you do it in 2023?
Repeal.
It's repealed.
It is repealed.
Repealed.
So therefore, how are you doing it in 2023?
And meanwhile, my lord, this notification has come on 10/3/2023.
After filing of the report.
In between these two notifications.
So your case is,
Right.
you may have holding tax at 3%,
Right.
but you cannot have the urban.
Urban.
That's in enhancement.
And enhancement, my lord. Because lordship kindly have a look at also page 49. We have filed in additional affidavit. Page 49, there is a notification is come in between these two notifications. And this notification has been acted upon, my lord. When it is acted upon, it cannot be revisited. Wherein says maximum 20% to be, 25% to be enhanced from the last tax. That is also a point of consideration.
Debate can be given to public so that the effective increase to the final property tax shall not be more than 3% of the
25%.
last property tax collected.
And in my case, my lord, it goes to
The
6.
rebate can be given.
It can be given. Yes.
But we are not concerned here.
Oh, yes,
What
that's
you are concerned with this notification.
yes, yes.
As per this notification, they have increased. What they have done is considered as 7.5% of the annual rental value is considered as 7.5% of the property value.
Yes.
Yes.
And what they did, my lord, they have engaged a third party. Now, suppose my land is 100 square feet. They also multiplied it by 1.5 times as per their affidavit also. So thereby the entire rental value increased. The entire, my land is 100 square feet. Now they calculated 100 square feet multiplied by 1.5 times. So the rental value, local rates has been gone up. That's their calculation. And also not compare
I fail to understand. Your land is 100 square feet.
100 square feet, my lord.
Means-
So it has to be the annual rental value that has to be calculated if there is a building holding tax, naturally there should be a building. Now the annual rental value, how every year how to be calculated? Circle rate of that land value and also the assessment of the building. So therefore the 7.5%.
No, without a building, how can you have a tax?
No. What they did, these 100 square feet multiplied by them by 1.5% more
What is 1.5%?
of the land, area of the land.
In 100 into 1.5.
Yes, 1.5. They
No, is it the value of 100 square?
no,
feet?
they increase the area. My actual area is 100 square feet as per their calculation chart. That multiplied by 1.5 times. No rationality. But my submission, my lord,
But
we-
that is one aspect.
yeah,
That is an incorrect method of assessment.
yes, yes. That is
But
another.
I'm not on that, but you're
Yes.
challenging here the notification.
My
So
only,
your notification, what is wrong with it? The challenge to 3/5/2023 here. You're challenging.
no,
3/5.
my basically, my lord, we are on that, section 79, they have said that 79A2D you have to follow. While assessment is the government notification. And they have not followed while assessment of the holding tax. They neither they taken approval of the committee. There is no existence of the committee, in fact, no approval. And they also introduce a new concept of this urban tax.
So
That's
therefore,
my
your-
immediate
so
submission.
therefore, your missions are twofold.
Yes,
One is 79D and E have been resorted to. 79C, 79D and 79E has been resorted to without a decision from the committee formed under 79A5.
yes.
That is the first. Secondly, a concept of urban tax have been included, which is outside the parameters of tax.
Yes,
as have been
79D, my
mentioned
lord.
in section,
79D.
no, not 70. It has been mentioned in 68.
68. This is the first section of the,
So urban tax which have been mentioned is outside.
yes,
So these are your contention.
yes, my lord.
Okay. Now let's see from the notification what is that. Here they have increased the annual rental value is considered as 7.5% of the property value. Earlier, what was it?
101, page number 101, there was one more notification. Which we have followed, Lordship, 28/6/2020. In pursuant to the notification, Lordship, the operation guidelines for the revision of property tax of the ULBs are there. What are the?
That is how to compute, et cetera, et cetera. How annual rental will do to become to.
This is
But
That
in
is the
this-
methodology,
But
my
in
lord.
this order of the governor at page 99, hence in pursuance to 79A5 of a committee under the chairmanship of the deputy commissioner of the respective area along with the following members is hereby constituted. Now, the question is, have you taken a action on the basis of this constitution? Constituted committee?
The final assessment does not say so.
As per our Lordship, in terms of 20th February 2023 notification, Lordship, the public here was conveyed. Lord.
Huh?
But as per page 27.
No, that I've looked into.
Lordship,
I'm not on that. But I'm asking you,
Lordship,
if you want to take action under 79C,
Lordship,
there has to be a decision by the committee.
committee.
And that too, when the government have already framed the committee, constituted the committee in terms with the order of the governor, dated 28/6/2022. Did you take in pursuance to page 99 any action in terms with this notification? If not, matter is over.
That instruction
We have to dictate now?
Lordship.
Now there is a affidavit they have filed, they have not said anything.
No, matter over. So we set aside it. You cannot do that. And I don't understand. Why do you want to take an instruction of a matter which is being lying pending from the year 2023 till late?
This-
No, we are not concerned with that. The question are twofold. You have an answer, we have it next Tuesday, we finish it off. I put it out, his arguments is this, you answer to me, his
Lordship.
as to. And if you don't have an answer, we pass the final order.
In
Matter
fact,
over.
this notification, my lord, earlier in the act, there was no concept of, there is no post of executive officer of the municipal. Now it's introduced. Now in the notification, the executive officer also included as a special invitee.
No, it's okay.
Lordship.
Heard Mr. P. Dr. Senior Counsel assisted by Mr. S. Dekar appearing on behalf of the petitioner And Mr. S.S. Roy, the learned counsel, appears on behalf of the Tinsukia Municipal Board, na?
Yes, ma'am.
And Mr. S.R. Guru appears on behalf of the respondent numbers 1, 4, and 5. The petitioner herein have assailed the notification dated 3/5/2023. Whereby the respondent in Super Municipal Board have not only increased the holding tax, but also had imposed the tax in the name and style of urban tax. Mr. B. Dr. Dolani, Senior Counsel, appearing on behalf of the petitioner, submitted that the power under section 79C, 79D can be exercised by the respondent authorities, provided approval is taken from the committee constituted in terms with section 79A bracket 5 of the Assam Municipal Act 1956. The learned senior counsel, referring to the orders of the governor or to the notification dated 28/6/2022 issued by the Commissioner and Secretary, Department of Housing and Urban Affairs, Government of Assam, submitted that in terms with the said notification, the committee was duly constituted. However, there's no materials on record or even the stand or there is any stand taken by the respondent authorities that the revisions so made to the holding tax, the revisions so made for refixation of the annual rental value of the holdings have been done with the prior approval of the committee so constituted. The learned senior counsel further submitted that in terms with section 68 of the Assam Municipal Act 1956, as well as section 79 and 79, 79A, 79B, 79C, 79D, and 79E. The concept of urban tax is foreign to the Assam Municipal Act 1956. However, by the impugned notification dated 3/5/2023, in addition to the holding tax, an urban tax at the same rate have been imposed by the Tinsukia Municipal Board. He therefore submits that the impugned notification dated 3/5/2023 is contrary to the provisions of section 79 C and D. And further, the imposition of the urban tax is ultra vires the provisions of the Act, Assam Municipal Act 1956. Mr. S.S. Roy, the learned counsel, appearing on behalf of the petition respondent, Tinsukia Municipal Board, submit that he would require instructions in this regard. It is unfortunate to take note of that the instant writ petition has been filed in the year 2023. And the affidavits have also been filed, exchanged. But there is no instruction on the issues, with the contention so raised. Considering the above, this court therefore fixes this matter again on 13th of November 2025. On which date an attempt shall be at 2 p.m. On which date an attempt shall be made to dispose of the
Grateful, man.
This issue was raised today on.
This is the end the act, man.
Only exorbitant was there.
They have mentioned that the AI is beyond the act.
Yes.
One of the prayer. That is there in the prediction. Unfortunately, Mr.
Yes.
S. Roy submits that he would make his submissions on the next.
May I please, my lord?
Yes.
This is a case pertaining to non-payment of contractual amount, my lord, otherwise admitted by the department. My lord, in
Not accommodation, no file, my lord. I think it's captured the department.
Referring to the DAD, madam, what I'm get the administrative that is the such kind of last occasion the PWD report was sought. So we are awaiting that report. Based on that report, my lord, the application will be given and then and not the PC bill. Apart, other money has been given. That what?
32.
That has been paid. Only that 5 lakhs for which he has done the case, that it is done on that report is reached out.
On the ground that the completion was not within time. Right.
my lord, it is not our fault that we could not complete the work within the stipulated time, my lord, because circumstances become such that we could not complete, my lord. Because this work was allotted to the petitioner, my lord, in 2018. After administrative approval, he started working on the project. Thereafter, my lord, in 2019, my lord, COVID came. And once the COVID came, my lord, we have to stop the progress of the work. And my lord may kindly come to last page of my writ petition, my lord. That will reflect the reason why we could not complete the work within the stipulated time, my lord. This is Annexure 20, my lord, justification on reason of non-completion of the work. My lord, at the last column, my lord, sir, reason for non-completion, COVID-19 pandemic, and second ground is that, my lord, labor camp is occupied as security camp by the civil SDO. My lord, whatever camp we have built up to accommodate our labor, my lord, all those camps were being occupied by the security service. Until date, according to my knowledge, my lord, those camps have not been vacated, my lord. And this is the report, my lord.
Your work has not been completed.
Yes,
Yes, my lord.
As per is the last page, digital progress. There it is given 42%.
42%.
This, my lord, the DAD has asked the PWD has give a report. So why it has not been completed? So we are waiting.
So are you giving up on the work?
My lord, now we do not want to continue with the work. Otherwise, my lord,
If you don't want to continue,
yes, my lord.
for that, there are various other aspects which has to be looked into.
Yes, my lord. There are some
It
other,
cannot be by way of a repetition.
but my lord may kindly come to page 49.
No.
No,
The
my lord,
question
work
is,
complete.
if you don't do
Yes, my lord.
the work,
Yes, my lord.
how can this court come to a finding out here that you are entitled for the work?
My lord,
which you have
that
completed?
entitlement will come from page 49. This is the work completion certificate, my lord, issued by the executive engineer.
I don't trust this executive engineer. I trust everybody but not them because they have committed a lot of problems.
My lord, this is the work completion certificate issued by the appropriate authority, my lord. The chief engineer, it was signed by the executive engineer, my lord. My lord, once my camp has been occupied by the security service and this is the work allotted in 2018 up to
This is
2023,
for
my lord.
renovation.
My lord,
Work is for renovation of SDO office,
My
including
lord,
art filling and construction of master drain.
master drain, my lord.
Master drain, what do you have to, what problem you have? You couldn't complete?
No, it could not be complete because, my lord, first reason is that the COVID pandemic came in.
COVID is there, COVID 5 years ago.
No, my lord, maybe it is
Then
5
you
years
should
ago.
ask for extension.
But my lord, once we,
You should have asked for extension.
my
no
lord,
case.
once we have asked for extension, my lord.
No case.
No, my lord, may kindly consider one aspect, my lord.
No, I won't.
This is the work completion certificate that has been issued. And secondly, my lord,
Work completion is only part.
no,
There's
once
no,
the,
it is not a case of balance outstanding. It is a case of a bill, some of the bill have not been cleared.
yes,
You have not given up the work till now.
no, my lord, may kindly come to
Have
page
you given up
47.
the work? No.
My lord, let the report be called for the time, being. Let the report be called for, my lord.
Report call for, nothing is there.
But one practical difficulty is that once my camp, which I have built up
No,
for labor
Mr.
accommodation, my lord.
Mr. Decker, you have to understand
Yes, my
one
lord.
thing. There are various consequences which will fall. You are now trying to abandon the work.
No, my lord,
You are trying to abandon the work. That give me 5 lakhs, I'm out.
no, my lord, let me do one thing. Let me take an instruction from my client.
For what?
Whether he want to continue with this work or he would like to abandon.
You just said that he
No,
was.
my lord, let me take an instruction. My lord, short date may be granted to me.
I short date. Leave it after 6 weeks.
Deeply obliged.
Till 6 weeks I am there, I'll dismiss this petition.
Deeply obliged, my lord. But let me take an instruction, at least one instruction from him, my lord.
Instruction normally I give 15 minutes.
No, my lord, it would be too short, my lord.
It's not too short. 15 minutes is not too short. You have to call up the client and ask him whether he wants to do the work or not. If you
No.
want to abandon the work, the question, there are various aspects. They
My
may
lord-
consider whether abandon. This is a part of a bill.
The part of the bill.
A part of the bill not being paid. If you abandon the work, these are works which are given on the basis of some contract. You are entitled to escalation cost. You are entitled to, if there are any problem out there, you may be entitled to many aspects. So if you have not done anything, how can you ask a
No, my lord, I'm totally understanding the perception of this honorable.
Okay, counsel appearing on behalf of the petitioner seeks an accommodation, lists the matter for weeks.
Deeply obliged, my lord.
We take it.
Well, no, copy to my dear.
May I please, Your Lordship? In this case, my lord, they have filed affidavit. My lord, at this stage, we are not required to file affidavit, my lord. Lordship may take up the matter for disposal, my lord. Yes,
It is against suspension.
cancellation,
You can cancel.
cancellation. And my lord, what happened in this case? License was, interestingly, license was issued in the month of, my lord, 14th of September. And that fact is also admitted by the respondent, my lord. Annexure 1, page 21. This license was issued on 14/9/2022. And inquiry conducted for the month of July and August, my lord. That is relevant, my lord. Inquiry conducted for the month of July and August. Inquiry report they have annexed in their affidavit.
Which one relevant?
My lord, in affidavit in opposition, my lord, they have filed. Page, my lord, 82.
82 I understand.
88,
Which one?
relevant 88.
No, my lord, page 82 is relevant. Page
88.
82, my lord. Page 8, lordship, firstly come to
What is
page.
your name?
My name is Jiabur Rahman, but clause 4 of the, my lord, reference in the inquiry.
No,
meant
kindly come here. Page 88.
Page 88. my lord.
In our field visit, dated so we have inspected about the operational status of the FSD, and from the collection data, it is revealed that Mohammed so has not operated the FSD to date. Instead of opening his affairs, he is supplying the FPTS commodities to his consumers to nearby FPS of Aldudana. Statement of some of the consumers and son of so may kindly be seen. By this case, they violated the cause of
My lord, before that,
hearing. the unclosed. The report, some of the complete statement are in the unclosed.
Before that, my lord, page 82, Lordship kindly.
It is for somebody else.
Yes, page 82,
Yes.
page 82, reference, clause 4, that is inquiry, complaint petition submitted by so-and-so, so-and-so, so-and-so for PMJ rice for the month of August and September 2022. That inquiry, entire inquiry, if your lordship find out the, my lord, number of persons who are inquired, all inquiry in respect of, my lord, July and August. July and August, my lord, August and September. And my license was issued only in the month of, my lord, September.
File appeal, file appeal.
My lord, they have
File
admitted,
appeal.
in their affidavit, they have admitted in paragraph 11. Paragraphs 11, they have admitted the fact that, my lord, I have not operated, my lord, and I have not operated
Para 11 is what?
of the affidavit in opposition.
I'll be respond number 3.
Yes, my lord.
It says that you got show cause notice.
Not so, then, my lord, then paragraph 12, that was the statement made in paragraph 17 of the report back to state that the inquiry report submitted by the then additional commissioner Morigao revealed that the fair price shop of the petitioner was not operational till the time of inspection by the ADC.
Inspection was done on 17/11/2022.
Yes, my lord, that is their affidavit, my lord. My lord, my shop was not operating. So question of my not committing any illegalities.
No, you have a license, you have to operate.
No, my lord, because my license was issued on the month of September 2022, my lord. And inquiry in respect of August and September 2022.
No. Your license was issued on September 2022.
Lordship.
Did you lift any PDS quantity?
No, my lord, because my godown was not ready. So accordingly, my lord, the Food and Civil Supply Department has made an alternative arrangement to distribute that commodities from a different, my lord, agent.
Where?
That is admitted, that is,
No, where is the document? Here the allegation is you on your own permitted this being used by another FPS shop. Where is that notice? Because if it is being lifted,
yes,
PDS commodity is being lifted
yes,
in the name of your shop, that means unless and until there is an order being passed by the authority concerned allowing under the FPS shop to run it or use that order to distribute that, it is a violation
my
of
lord,
yours.
I have not lifted. That is the position, my lord. I have not lifted because August and September.
No,
License.
No, this is the question of facts which we can't look into it. It is very clear out there. Unless you show me some details that this particular shop which was given to you, you see the statement.
Yes.
How much so and so not operated till date. Instead of opening his AI, he is supplying the PDS commodity. This is the allegation.
Yes, my lord.
To his consumer through nearby FPF shop. You cannot give it. It has to be given only by the authority concerned.
Yes.
If this allegation is true, this number 2 at page 188
Yes.
is true.
Yes.
Write it.
Then, my lord, day after tomorrow, I'll obtain that instruction.
What?
Whether that commodity was lifted by that agent, because I cannot lift it.
But for that, you have to file a reply if you want to. Otherwise, it goes on the case.
Then I'll
That
file.
ends now at 2:15.
Yes, ma'am. And complaint or
No, my lord, then I'll file affidavit, lordship, with 1 week's time,
I asked you.
lordship.
complaint or the hospital, ma'am. So that's why the inquiry
Complaint
was
for
done
the
in
period.
Case of all the, my lord, that's why, my
Those are nothing
was
to
given, ma'am.
Complaint for the July, August and September.
Forget about July, August. The fact remains that you got the license in the month of September. In your license, would have been here. Now you are saying that it is the authority of the, show me, otherwise if you have permitted any other FPS shop to run it, then you are in a violation. Rightly gets it.
Yes, ma'am.
Yes.
Dismiss.
No, my lord, I'll file an
Or
affidavit.
file appeal.
Affidavit, my lord.
File appeal.
No, my lord, I'll file an affidavit.
No, appeal.
My lord, pleadings are completed, my lord. They have filed affidavit. Just
What is the
I'll
pleading
clarify
completed? Let
because
us
my
dismiss it.
lordship, what happened?
Yeah.
Lordship, what happened? I have filed my affidavit. They have filed affidavit. I clarify that position, my lord. I'll clarify.
March.
Huh?
In the month of March.
Goodness.
My lord,
March.
on that part, only on that part, my
This is
lord.
the main point, the crux.
My lord, they filed affidavit after 1 year, my lord.
Anyway, let me record it so that the next judge who takes it up,
Yes.
we take it up next Thursday
Lord.
and finish it up
Next Thursday. This.
next Thursday. Oh, this coming Thursday.
Sixth,
Today,
on
Sunday, no? Okay, next Thursday, we finish it up.
Can it be Friday, my lord?
Why?
Because
Good day.
Wednesday is a holiday, my lord.
You only get your instruction. Produce me a letter today. I'll give you permission.
Lordship.
Heard Mr. J.M.A. Chaudhary, the learned counsel appearing on behalf of the petitioner, Mr. Yudas, the learned additional senior government advocate, appears on behalf of the respondents. The petitioner herein have assailed the order dated 21/2024, passed by the Assistant Director FPDNCA Morigao, whereby the license of the petitioner was cancelled on the basis of an inquiry report dated 13/12/2022. From a perusal of the said inquiry report, it is seen that the allegations against the petitioner, and that it is seen that upon making necessary inspection on 7/11/2022, it was found that the petitioner, though was issued the license in the month of September 2022, but was not running the fair price shop. It was also alleged it was also mentioned in the said inquiry report that instead the petitioner had lifted the PDS commodities and supplied the said commodities to his consumers through a nearby fair price shop of, what is that?
Hormuz Ali.
Hormuz Ali. And this aspect is also verified on the basis of the statement of the consumers and Hormuz Ali. This court inquired with the learned counsel appearing on behalf of the petitioner as to how the petitioner can allow the lifted PDS quantity, which is assigned to his fair price shop, to be distributed through another fair price shop. So the learned counsel submits that he would obtain instruction and place the said aspect before this court on the next date. List the matter on 6th of November 2025 at 2 p.m. for final.
Argued by my senior T.J. Mohanta, who is now election court number 3, my lord. T.J. Mohanta, my lord. My lord, on the other hand, my lord, they are sold.
Number 2.
Sold,
number two.
sold, on the other hand, my lord, sole respondent number 2, sole respondent of deputy commissioner of the district, who, based on which work order I transported the item, he has not filed any affidavit as yet.
Not necessary. I
So, my
don't
lord,
go
kindly
by
at any day, my lord.
Let
Any
us
time
see
next
what
week.
is your case? Outstanding amount
Yes, my lord.
of 3 crores for transportation,
Yes, my lord.
period 2020-21. Yes, why haven't you paid?
We have filed the affidavit on behalf of customer number 3.
Why haven't you paid?
In fact, according to us, we have made excess payment to him. No amount is due.
You have paid excess payment. Where?
In the affidavit kindly seen. In paragraph 4, We have deleted. relevant portion is 37. Page number 37, the last
37.
37,
Ah.
yes. Last
As per
paragraph.
government now, the transportation cost of the to 2020-21. It was in growth and so whatever additional amount is the book. Right. Further for. What is your reply?
My lord, kindly see my lord, page 21.
What page?
My lord,
Your reply.
yes, reply there. My lord. Paragraph 4.
You were issued the work order on 29, 2019.
Yes, my lord.
And here you are mentioning about what, Mr. Nath? This is 2021.
Well, this work order relates to NFSA rice. There are two schemes. One of the rice, the 2019 order relates to, and you see, page number 15,
Date?
page 15 in the petition. Annexure A. This is the work order they have referred.
One. Page
Annexure.
15.
Yes. Subject is
Regarding rate of approval for NFS. Okay, 2019-20.
2019-20 NFSA rights. And here, one of the rate for Dhubri Sadar subdivision is given. Bilasipara civil subdivision is given 142.99 and Bilasipara is 142.94. They now claim that they have also transported rice during COVID period under Prime Minister another scheme. That is,
Anna Garib Anna.
yes, Prime Minister Garib
Kalyan.
PMGKAY. So they said that they are also entitled for that. But according to us, as per the report, under this PMGKY scheme, if payment is to be made per 100 rupees per quintal. So they are not entitled. to
So this is under the NFSA.
This is under NFSA.
But where is the work order for PM? Huh?
They have not annexed.
My lord, kindly come to page 21, my lord. Page 21, last paragraph, my lord. That is the letter issued by the deputy commissioner, which he has communicated to the commissioner, my lord. Last paragraph, my lord. In view of the above, I would like to request to kindly to consider the prior petition of the petitioner Uttam Kumar Shah, handling and transport contractor, my lord, Dhubri, for payment of transportation bill, PMGKY,
Okay,
right?
transportation bill under PMGKAY
Yes,
must
my
have been based upon some work order.
My lord, original, my lord,
Where is that work order? This is under the NFSA and PMGY. Regarding transportation, it is both. Mr. Nath,
This later.
page
my lord,
17, this is page 15. Page 15 is only NFSA.
And
page 7.
And page 17 is had submitted a petition expressing his willingness to continue transportation of both NFSA and RIA for the financial year 2021-22 as per the existing approved rate. So what is the existing approved rate? These are questions of facts.
Well, my
Why
lord,
we can't help you?
thereafter, my lord, the deputy commissioner admitting the balance amount, he has written.
Deputy Commissioner writing out there would not do because the payment has to be made by the government and the central government has to make the payment. Have you made the central
Well,
government a party?
commission, in this, commissioner also my lord, said a letter
No,
admitting.
Have you made the central government a party? No central government. Yeah? Where is the central government? Without the Union of India, how on earth can you get this thing? Tell me. Hey, NFSI এখন দিয়ক। আপনার food security.
My lord,
That is
person to work order issued, but well, any day of the next week, my lord. Any day, my lord.
10,000 cost.
My lord. Any day, my lord. On the otherwise also, my lord,
Okay.
Mr. Mohantul sir,
request
sir
of
will
the
argument matter.
Counsel for the petitioner, the matter stands adjourned to be listed on 28th of January 2026. Okay.
My lord.
Good date, 2nd of February 2000.
Sorry, my lord. Earlier on, my lord.
2nd of. Yes, what is this? Here, Mr.
Same,
TC
my lord,
wants
same.
to- 2nd of February. Next. This matter is also same.
Same, my lord.
Huh?
This is South Salmon.
South Salmon are another.
Earlier one is Dhubri district, second one
It
is
is South Salmon.
Here one, so same.
Same.
Okay, 2nd of February 2000. But we have a problem without making the central government a part. Because NFSA, you cannot get a single penny or a PMJY because it is something like it is a scheme under the government. So the payment, if I direct them also, they will just come up later on, say that look here, the central government is not paying. It is something like those water resource department matter. When it is under a central scheme or a state scheme, the central scheme, you have to make the central government a party. Anyway, you don't know. 2nd of February 2026. Okay, yes, what is this? Admitted amount?
Yes, Lordship,
What do you say? Executive engineer. These are of 2016. Why should we pass on your order?
Lordship, the
When did you file the requisition? 24. Why should we?
notice was already issued on 15/5/24.
What?
Notice was already issued on 15/5/24.
Notice was issued.
Yes, Lord,
By?
by Justice Silo, by this honorable court, Justice Silo.
Notice only issued.
Yes, Lord.
I dismiss it. Today is for admission. I'm not entertaining this
And
type of.
Lordship,
litigation.
similarly situated,
Why have you approached this court after 8 years?
Lordship, they were trying to,
The trying does not help. Lekhok. Heard Ms. P. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. Aibot Thakur appears on behalf of the PHE department. The petitioner herein has sought for a direction from the court, thereby directing the respondents to pay an amount of rupees 5,73,806 on account of the same being due to the petitioner. For the work completed by the petitioner. Full stop. It is relevant to take note of that the petitioner herein claims the said amount on the basis of work carried out on the basis of certain work orders issued to the petitioner on 5/1/2006, on the basis of 3 work orders issued to the petitioner on 5/1/2016. on the basis of work orders issued on the basis of various work orders issued on 5/1/2016, 21/2016, and 29/1/2016. It is stated that the works were duly completed by the petitioner. And in that regard have enclosed a completion certificate of one such work. However, the said completion certificate is not dated. The record further revealed that the petitioner thereupon
For other similarly situated contractors,
this time dismissing.
your lordship had passed orders disposing of their petition. They are all similarly situated.
Where is the verification here? In this case? In that case, there was a verification done. It was seen that pursuant to the order passed by this court on so and so, a verification was conducted by the respondent authority, and it was found that out of the amount of so and so as claimed by the petitioner is actually entitled to, which have been duly mentioned in paragraph 3 of the affidavit in opposition. Where is it here?
Lordship, they have to do that
no,
verification
no.
exercise. It was because of your lordship's order that the verification was conducted.
No, nothing doing. No. It is seen that thereupon the materials on record thereupon do not show what steps were taken by the petitioner as regard for the purpose of realization of the said amount alleged to be due to the petitioner. It was only in the year 2023 that too, in the month of November, the petitioner submitted a representation to the executive engineer PHE division Hosai. Who has submitted?
It was a joint representation, Lord.
A joint representation was submitted by various contractors to the PHE department, including the petitioner.
Okay.
And thereupon has approached this court by filing the present writ petition. Mr. I. Bhattakur, appearing on behalf of the respondent PHE, submits that taking into account that the petitioner has approached this court after 8 years, and there is no materials showing that there is any completion in respect to the various work orders enclosed, it is difficult on the part of the respondents to make necessary, to carry out the verifications at this late juncture. The learned counsel further submitted that this is a case where the petitioner have failed to have slept over his rights. And the learned counsel further submits that if the instant writ petition is entertained, it would result in taking away, it would result in taking away a valuable right of the respondents. বাড়িখিনি মোৰ যে আছে আজি ৰাতিপুৱা এটা order has been slept over the mat.
I'm paying this time to file certificate.
এই ৰাতিপুৱা এটা order দিছো ন dismiss.
I was directed to file affidavit in this case, but you have paid 9 days for the time to file my.
Huh?
On last occasion, Lordship directed me to file affidavit. Lordship, I required 10 days time because the Lordship, there was a administrative problem in the university. They could not file.
You have not filed the affidavit.
Lordship, I required for the 10 days time.
You impose a cost.
Lordship, in this case, Lordship, there are multiple proceeding is pending.
What?
There are multiple proceeding is pending.
So what?
Lordship,
How many times you have taken time?
only once.
What
Lordship,
once?
Lordship directed me to,
I gave you time on 28
no, Lordship, before that, Lordship.
and
directed
again,
me to
again on 10/9.
Appear person.
You say that you have received instructions and filed the affidavit in a week's time, and the matter has come up after 2 months. You have not filed. Do you want to file or don't want to file? Don't file, don't file.
Lordship can hear the matter.
Okay. Are you?
Well, the matter, this NIT impugned here, he has been stayed in a arbitration appeal 7 of 2020. It has been stayed in another proceeding. On last day order has been shown to your lordship and we have come to learn here.
Yes. Are you?
That is, my lord, impugned, NIT impugned page 61.
You have challenged the notice inviting.
Yes, that has been stayed in another arbitration appeal 7 of 2020.
Forget about that. We are concerned with this.
So, my lord, that is what, that has been stayed. That is my, for your lordship, my lord.
Very good. In that case, it is okay. But here I am asking you, what is your case?
Case that NIT.
Because here I am exercising 226.
Yes.
Now the question of interference with the terms of the tender is very limited.
Yes.
So therefore argue as to why this court should interfere with the terms of the tender.
My lordship may kindly come to page 61.
It's
This is NIT. 16/8/2024. Here, my lord, that is the bid dated 16.
Huh?
Third column, lordship. Bid offer validity 180 days. Then, my lord, that is in the on 16/8/2024. My humble submission is that.
So nothing remains.
That is my humble lordship.
Record in the entry.
That is on that basis, my lord. This is my interpretation.
Bid validity, bids must have been submitted.
Yes.
And bids have been submitted. If you don't continue to, nothing remains out there. Have you given the work order?
No, Lordship, because the arbitration proceeding is going.
No, there is an arbitration proceeding going on. This is a different aspect. Who has filed? Not them.
No,
No.
another.
Okay. Now, the question is whether do you want to continue with the challenge or not?
That is our challenge is that on the ground there, they have imposed on some condition, which is my lord that my pleadings at
Don't
para.
Which are the conditions?
Pleadings at the my lord at page 63.
Hmm.
They impose years of past experience required.
Ah.
Bidder must have experience for number of years as indicated above and bid comment.
Where you are reading which one?
Page 63, Lord.
Ah.
Para condition 1, para 1.
Ah.
Years of past experience required. The bidder must have experience for number of years as indicated above in bid document ending March prior to bid opening.
providing the similar type of service to any central government, state organization, PSU, copies of relevant contract. So that is, they have restricted to this, and we have sufficient experience on providing the service, the bus services to the education institute.
I don't understand. The bidder must have experience for number of years as indicated in the bid document, ending per month of so and so prior to the bid opening, of providing similar type of service to any central government so and so. Copies of ER to be uploaded along with the bid in support of. Then what is wrong with this?
My lord, this, that they have, my lord, it is a, my humble submission is there. It is restricted the competition.
Because they have asked for experience.
Yes, some, so only to that extent, to some organizations. central
That's
government.
your only
We have
contention.
experience. We
That
have
is the only contention.
Then another, my lord, para 3.
Para?
3. That is therefore the then my lord, para 2. Preference will be MS having valid Uddam registration. We have also.
Are you MSc?
Yes, lordship.
Okay, where is your MSc certificate? Where is your MSc certificate?
Lordship, actually, I am not to. I support that they will file affidavit.
No, no.
So in
where
depth,
was
I
there?
have some. That is what I'm
Not
facing
there.
difficulty
Anyway,
to
have
lead
you
your,
mentioned that you are an MSc?
to lead your lordship this is
Have
submission.
you mentioned that you are an MSc? No.
No.
Matter ends then. Number 2 is gone. Then come to number 3.
Then I'm coming to number 3. They have this estimated bid value indicated above is being declared solely for the purpose of guidance on EMD amount and for determining the eligibility criteria related to turnover, past performance and project, past experience, etc. This has no relevance or bearing on price to be quoted for the bidders. Number 1 saying this experience is required. Para number 1 saying condition that experience is required, that you have experience in the state governments, etc. Here, my lord, estimated bill value indicated as being declared solely for the guidance on EMD amount and for determining the eligibility criteria related to turnover, past performance, and project, past experience, etc. This is not required.
So?
That is 1 and 3 is contradictory.
Absolutely not.
Okay.
You were very lucky that you got a judge on that day who had issued notice. If it had come before me on the first day, I would have dismissed it. Now I dismiss it right now. Heard Mr. He's not done. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S.C. Kyle appears on behalf of the
1, 2, 3.
1, 2, and 3. 3 also.
Not.
The petitioner herein have assailed the terms and conditions of the notice inviting tender dated 16/8/2024, bearing bid number GEM/2024/B/5290330. It has been submitted. It is the case of the petitioner that by the said notice inviting tender, the respondent authorities have incorporated certain terms which are restrictive. It is being submitted by the learned counsel appearing on behalf of the petitioner that in terms with clause 1, the respondent authority have permitted only those bidders who have experience in a number of years of providing similar types of service to any central government, public state government, public PSU, and have also sought for relevant contracts of the orders to be uploaded along with bid in support of having provided service during each of the financial year. The learned counsel submits that this particular clause is restrictive. In the opinion of this court, the said submission is completely misconceived. Inasmuch as the owner of the owner, in as much as the tendering authority has the right to incorporate certain terms and conditions, and including seek bids only from those persons who are experienced. Under such circumstances, the first submission is misconceived. The submission as regards clause number 1 of the bid document is misconceived. As regards clause number 2, the learned counsel submits that there are also preferences being given to another. There's been what do you say about clause number 2?
Clause number 2, my lord, I am not.
Nothing. The learned counsel further submitted as regards clause number 3 and submitted that the said clause number 3 is contrary to clause number 1. Inasmuch as it is stipulated in clause number 3 that the estimated bid value indicated is being declared solely for the purpose of guidance on EMD amount and for determining the eligibility criteria relating to turnover, past performance and project, past experience, etc. The learned counsel submits that the said clause is contrary to clause number 1 in the opinion of this court. There appears to be nothing contradictory between clause number 1 and clause number 3 on the face of it. So, considering the above, it is the opinion of this court that no case has been made out by the petitioner for interference with the said tender document. So, it is also, this court also finds it pertinent at this stage to refer to the judgment of the Supreme Court in the case of FCONS versus Nagpur so-and-so, reported in so-and-so, more particularly paragraph number 15, wherein the Supreme Court categorically observed that the author of the document, that the tendering authority being the author of the document, has liberty to incorporate such terms and conditions as the tendering authority feels for getting the best procurement service. Accordingly, the instant petitions and
17.
Yes.
What is this? My lord, the petitioner was allotted with some works under Jal Jeevan Mission and 16 projects. Now, my lord, when he completed the works till at least 90%, none of the bills were paid. And suddenly, my lord, on 11/3/2024, 5 of the works were terminated. And this termination order, which is at page 23, has not been intimated to the petitioner. My lord. He got to know about this order in a
What has
WhatsApp.
happened now?
Now, my lord,
There is no stay.
no stay.
Termination has happened.
Happened, but even after this order, my lord, because this was not within the knowledge, he carried on the work. But of course, after filing of this writ petition, he has stopped work. Now, more than 90% work is done. They have also admitted that they have, I mean,
After termination also you carried out.
because it was not within my knowledge. It was never informed to us, this
Then?
termination order. We were carrying out the work. Then we came to know about this order by in a WhatsApp group. And then I went to the office and verified and then came to know about this order. Now, my lord, all my investments are gone. Now they are saying, what this order is saying, not only they have terminated the work, hereby cancel the balance
Just
work.
stand, Mr. Botapur.
Madam, we had given a show cause notice also, and from time to time, madam, we have communicated. In our affidavit, madam, we have brought it on record. And because there was no progress in the work, it had to be terminated. And we had then allocated.
Madam, why you are not filing reply then? You don't want to file?
My lord, we'll file, my lord.
Was there any work done by them after the termination?
As per our instruction, it was not done, madam. We allotted it to somebody else, and some other.
They are saying, my lord, the performance guarantee is also forfeited.
When did you terminate? 11/3.
11/3/24.
Now tell me, on, kindly come to page 175. By this communication, you permitted the petitioner to complete the work, expedite their work with the target of completing the work in all respect latest by the end of March 2024. Isn't it?
Yes.
Then why did you terminate on 11/3?
Because, my lord, he did not reply.
But because these are all contradictory, page 175 and 177. Final show cause to failure to complete. Same date. Why these are being issued? Therefore, you are asked to 7 days time why complementation should not be given. This is given by the district mission director from executive engineer, so and so. Now this is being given by the junior engineer. Why these are different things which are being doing? Everybody is doing different things. Huh? Now, did you receive this focus notice?
No, my lord.
This one?
No, my lord.
177?
No, my lord. I never received any show cause notice. And then I was visiting their office asking for my payments. They never informed me that this has happened and all these were in existence, my lord.
How did you serve this document? Page 177? Produce your records, the PN book?
I called for records.
Produce the records?
Yes.
You produce the, madam, you want to file your
I'll
reply,
file in
you
the
can
meantime.
file a reply. But in the meantime, let them produce the record. Because if this notice has not been issued to you, and this they are basing upon that, we need to interfere with that on the basis of principles of natural justice. Hello. Ms. P. Chakraborty, the Learned Counsel appearing on behalf of the petitioner submits that she would like to file a reply to the affidavit in opposition. More particularly, in view of her instructions that the various documents which have been enclosed to the said affidavit in opposition were not received by the petitioner. Good stop. Taking into account the above, list the matter again on 24th of November 2025. In the meantime, the petitioner is given the liberty to file the reply on or before 21st of November. Thereafter, we'll consider as to, because without this reply,
My lord.
you don't have a case.
18.
You don't bring the records now. Let them. None appears for the parties. Oh, you are there. What is this? Non-payment,
Contractual bill, madam.
Tiwa. Is
My-
this Tiwa?
Madam,
Where?
page number 50.
Ah, Tiwa, I told you, na?
Yes, ma'am.
Because certain amounts we just look into and find out. It's 3 lakhs installment paid, 2 is remain.
Madam.
Where is Tiwa? You should have got hold of the Tiwa council. You would have come out here and say, then look here, we have no objection. We will make the payment. Where is she?
Well, after some time,
She's a
madam.
lady advocate, na?
Madam,
Where is she?
madam may take it after some time. I will inform her.
Get hold of the standing council here. We'll pass that similar order to the.
Madam.
19.
Lordship, we have filed our affidavit in reply today morning, Lordship.
Who has filed?
We have filed our reply, affidavit in reply.
Security deposit. We have not given.
We have served the copies. We have served the copy, Lordship.
You have filed reply.
Yes, yes, Lordship, we have filed the today itself. Lordship.
It has not
Today
come on
morning,
the
we
list.
have filed the reply.
Now, what do you want? What is your stand?
They have not deposited the load security amount, my lord. Load security amount. In my
Load security, what does load security has to do with security deposit and performance guarantee?
my affidavit in opposition, my lord, paragraph number 5. Page number 38.
Okay. So no liability certificate could not be issued to the petitioner due to non-charging of the transformer. You have not done that?
Lordship, the letter dated 19/2022 no establish the fact that the petitioner has ever informed or given reminder to deposit the load security amount.
Now you know, do that.
That is in their repetition, my lord.
We have,
Page number, annex 10, my lord. They were informed, my lord.
we have completed the work, Your Lordship.
Regarding load security bill against 100 contractors to the with reference to even a copy of the letter of the, it is to inform you that the load security is in your scope of work as per. You are therefore requested to do it. Then, no case. This is apparently there. Though you deposit, then only you will get it.
Lordship, we have also not got the security deposit, Lordship.
You cannot get unless and until you don't have the no demand certificate. Hello, dismissed.
Lordship.
You do one thing. Taking into account what they are saying, you withdraw the petition, do the deposit, whatever is necessary, and then they will grant you. That is the way out.
Lordship,
Instead of getting a dismissal.
Lordship,
Let us see the scope of the work. Where is the scope of the work? When did you complete?
Lordship, we have completed. Completed our 16 to 21, Lordship.
What contract do you have included? Repair renovation of existing room for CT scan at 12 on turnkey basis. Does it include the transformer?
Lordship, we have relevant portion agreement also next week, Lordship. Yeah.
What is the scope of the work? This is repair renovation of
repair, to
existing
repair.
room for CT scan facility at SM Hospitals when
Kasar district.
but does it include the transformer? We have not enclosed the entire document, Mr. Council.
Lordship, kindly come to Annexure 3, Lordship. We have also purchased a fixed term deposit with SBI amounting 1,48,000, Lordship.
Huh?
Come to Annexure 3, Lordship, of the petition here.
No, transformer is,
You have deposit the term, fixed term deposit, Lordship, 1,48,000.
where?
Annexure 3, Lordship.
Now, your reply, you see, I'm to Annexure 10. Page 33. It says about is to inform you that a load security amount is in your scope as per the approved estimate. You are hereby requested to pay the amount of load security at the earliest to the APDCL for timely charging of the transformers. What is your reply? Your reply is at page 34. You don't say that anything about the security deposit.
Lordship, from the respondents, they have not informed us to deposit your Lordship.
How is it possible? Page
So,
33 is the document and page 34 is your reply to that document. Have you read your petition or not properly?
Yes,
Kindly see page 33. What is the number, date of the document? Page 33? Date is 23rd of November 2021. Issued by the Chief Consultant National Health Mission. And now you reply, see page 34, 10/1/2022. See reference to that same communication. You don't say anything about that. What do you want? Dismissal?
Lordship, you will give us some time to
What?
for the hearing, your Lordship, next day.
Huh?
Give some time
For what?
for the hearing, Lordship, for the
Hearing done. How much hearing do you require for a non-payment due matter? Tender matter wouldn't take so much of time. How much it has taken for your matter?
and please, Lordship, it's my request, please grant some time to.
You have not stated that load security is not a scope of your work. And they categorically say that the load security is a scope of your work that has been mentioned in page 33 and 34. It has not been done. Have you paid the load security?
No, Lord.
Then matter over. What is the amount of load security?
2 lakhs.
Huh?
43,000.
3 lakh.
42. Page number 40. 43 of my affidavit.
That's 43,000.
Two lakh
43.
43,000. This is being paid by you. And how much is your load security deposit?
Security, Lordship,
1 lakh 33.
So be happy.
1,39,750.
1,39,750.
Lordship. Yes, Lordship.
And you have to pay 2 lakhs. to get 1 lakh. You do one thing, I give you time. Find out from the entire agreement whether load security is a part of the document or not. Otherwise, your client would not have approached you for the purpose of getting 1,39,000 to get an order for payment of 2,48,000. Okay? You have filed your reply.
Yes, Lordship, we have filed.
It has been submitted that a reply has been filed to the affidavit in opposition to list this matter on 19th of November 2025. The registry shall bring on record the said affidavit, the reply. You get your instruction, and if necessary, find out what is the scope of the agreement, whether load security transformer is a part of that agreement or not, because it is on a turnkey basis.
Outstanding bills for supply of the relief materials. My lord. Out of the same quotation, your lordship has disposed of the sets of writ petitions, my lord, wherein with the direction for verification, and if the petitioner is entitled for that, and the amount shall be released, my lord.
Which one?
But out of the same quotation.
What did you supply?
My lord, the relief materials, my lord. These are variety of soil, masoor dal, mustard oil, and brand name, my lord, then the iodized salt, sira, gur, polythene sheet, tarpaulin, cattle feed, and baby food, etc. The same materials, my lord. Only
How much? 23 lakh.
yes, my lord. 23 lakhs, 27,960.
Yes, Mr. Datta.
The document is to the Indian language. Whereas a committee was constituted to verify a committee was constituted by the department to verify the individual eligibility. This is under process. Otherwise, document is of this language.
I'm directed to make the verification whether all these things, kindly see paragraph 7.
No, I have done through.
Thing,
In this line, so
My lord, 21, 22, same.
same.
21, 22. Only the amount is much of less.
May I, madam? Well, standing counsel Tiva is not available today, madam.
Item 2, it's the matter after 2 weeks. Taking into account that the standing council of the Eva Autonomous Council is not available, matter stands adjourned to be listed again on the 6th of November 2025. It is observed if on the next occasion, the standing council is not available, the support shall dispose of the instant petition on page immediately available.
Obliged.
23.
Yeah, please, Your Lordship. Lordship, matter pertains to non-payment of contract is bill, Lordship.
We have not filed the affidavit, my lord, but it appears from the records, my lord, annex by the petitioner, that petitioner has not submitted the final bill. This is
Lordship,
lordship, annex of 4 page 21.
Lordship, we have submitted our final bill, Lordship.
No, what is the records?
And this is the fourth time, Lordship, we are seeking time to file reply. Since last 3 times, they are seeking time to file affidavit in opposition, Lordship. This is the fourth time, Lordship.
Annex of 4 page 21, my lord. First line, incomplete final bill, my lord.
Yes, Lordship.
In all the annexer, he has annexed my lord in the repetition. It clearly repeats that the incomplete final.
Because Lordship, originally, Lordship, the contract was
You
for,
completed the work.
Lordship, a particular stretch of work has been completed. That is why it's an incomplete bill. And the same road has been inaugurated by then Finance Minister, Dr. Hemant Biswa Sarma also. So that road is now completely in functioning and has been completely to the satisfaction of all the respondents. They have also made a partial payment of 3 crore, Lordship. They have already made a partial payment of 3 crores on 7th of November 2020. The total bill was for 8 crores 78 lakhs 954, out of which 3 crore has been paid. The rest 5 crores 78 lakhs 954 is still pending, Lordship, till date.
You mean to work order?
Work order is page number 7 and 8, Lordship.
Okay. 20.
Page number 7, Lordship. Para 4.
Huh?
Page number 7, Lordship.
Work
7 of
order,
the
where is the work order?
Annexure 2, Lordship.
So you have completed this 3.90 kilometers.
Yes, Your Lordship. Yes, Your Lordship.
And have you been issued any other work order?
There's 2 work order, Lordship. One is in Annexure 3 and one is in Annexure 4. This Annexure 4 is the complete bill, Lordship. Sorry, Annexure 2 and 3, Lordship.
And where is your final bill then?
Final bill, Lordship, the total work was for, Lordship.
5.60 kilometers.
No, Lordship, it was approximately for 17 crores 71 lakhs 40,992. But Lordship, due to non-availment of land, we could not complete the whole entire construction. So Lordship, a particular stretch has been completed for which we have raised this incomplete bill, Lordship. That was not like that portion of land could not be completed because of non-availability of land, Lordship. They could not procure the land. At that time, Lordship, due to change of government also and then post-pandemic, Lordship.
So what is the stretch you have completed?
Stretch, Lordship, from Lordship, Labon Ghat to Dethor stretch we have completed, Lordship.
How much? What is the kilometers you have?
Lordship, and find in
Total is you are to complete 4.50 kilometers.
Yes, Your Lordship.
How much you have?
Lordship, may come to Annexure 4, Lordship. It's in page number 21.
Where is your statement that you have completed this much only and it could not be done further on account of non-availability of it in your petition?
Lordship, for that, Lordship, I have to seek instruction from my client on that.
I mean, you have made a statement now.
Yes, that was informed by my client, Lordship. But Lordship, this section, Lordship, 3.90 kilometer in Annexure 4. And 2.60, Lordship. This work has been completed and the same bill has also been raised. Lordship, this is an admitted liability, Lordship. They have in Annexure 9, Lordship, page number 83. The Chief Engineer, PWD Roads, Assam, has written a letter to, oh, sorry, this Lordship, Public Work Department, Dispur has written letter to Chief Engineer, PWD, Lordship. May I read, Lordship?
No, you come to page 33. You say that the first work has been completed of 2.60.
Yes, Your Lordship. And subsequently, Lordship,
As point 3.90, you have only done partial.
3.90, Lordship, subsequently it was completed, Lordship.
When? If you have completed, then 5.07 would not have come in.
Lordship, this
Your
3.9,
entire claim is 5.07, yeah.
and Lordship, the total claim is for 8 crore 78 lakhs.
Well, why didn't you read page 33? Don't read and come before the court. You say that 2.60 you have completed.
Yes, Your Lordship.
By 3.90 you have partially completed, for which it is 260. And total is 8 crores, out of which you have received 3 crores. The claim is now 5.07.8. 5.07 crores.
Yes,
Isn't that your claim in your petition? Means obviously you have not completed 3.90.
Lordship. Lordship, these both are like, Lordship, in Annexure 4, Lordship, we have submitted this incomplete
Answer.
file, Lordship. 3.90,
What is your claim in your petition?
Lordship, for this pending amount, Lordship.
How much?
5 crore 78 lakhs 954.
5 crores 7 lakhs.
78.
5 crores 7 lakhs 80,954.
54, yes, Lord.
Isn't it?
Yes.
Come to page 33.
Yes, Lord.
Isn't it? So you have therefore not completed the second work of 3.90. Kindly see it.
Good.
There has been first paragraph number 2.
Yes, Lord. Just partially completed. If your Lordship may kindly give me some time, Lordship, I'll just take instruction, I'll come back, Lordship. I'll just make a call, Lordship, just for timing, Lord. Matter may be called again.
No time being. I heard Mr. So-and-so, the learned counsel appearing on behalf.
Lordship,
of
they may
the
file affidavit, Lordship.
Mr. J. Here, the learned counsel appears on behalf of the party along with the counsel. Mr. P. Gogoi appears on behalf of the PWD department. The petitioner herein has filed the incident with petition claiming an amount of 5,07,80954 as due to which the petitioner is entitled to for completion of as the remaining dues to which the petitioner is entitled to for completion of one work and for partial completion of another work.
Yeah, please, your
Notice
Lordship.
that the respondents have not filed an affidavit despite various opportunities have been granted to the respondents. since 24/1/2025.
Apologies, Lordship. May I please interpret? Lord?
Considering the above, this court fixes this matter again
A short date, ma'am.
on 28 November 2025.
Lordship, if you can be at 27th, Lordship.
The respondent, Karbi Anglong Autonomous Council, who were under whose aegis the work orders were issued to the petitioner on (29/2/2020) shall bring on record their affidavit as to whether the petitioner has completed the work in terms with the work order enclosed at Annexure 3 to the petition and have partially completed the work as per Annexure 2 to the petition. List according.
Lordship, we'll file additional document, additional affidavit, Lordship, bringing on record the completion of the entire project. I was just informed by my client. We can.
The council, I took that order. You had the opportunity, let them fight.
Lordship, only if it can come in first week of December, Lordship.
Huh?
If the matter can be fixed in the first week of December or before 28th of November. There's a marriage in the family. Lord. First week of December.
First of
Highly obliged.
It is observed that if the respondents do not file the affidavit, this court shall dispose of the petition on the basis of the materials already available on record and applying the doctrine of non-perverse.
Highly obliged.
Wait, Mr. Lordship.
Yes, what is this?
This. We have paid for to set aside the National Lok Adalat order dated 14/9/24, which is at Annexure.
They have filed the affidavit in reply?
Yes.
You're not filing any reply?
No, Lord.
You are challenging the order of the National Lok Adalat. What is the ground? Because you were not issued a notice and the council out there appeared without instruction.
Instruction and the representative of the company was not there at the National Lok Adalat. He was absent.
And he appeared without instruction.
Yes, Lords.
You have filed also an objection, na?
Yes.
Before the Bar Council against the.
Yes, Lord.
You have filed the affidavit. Who are you?
I'm for the district one worship. District one worship.
Who has filed the affidavit? Affidavit has been filed by?
One worship. I'll be one.
Affidavit filed by respondent number 2? Or respondent number 1? What is your case?
Lordship, my case, Lordship. I have two issues here, Lordship.
No, here is a case that advocate appeared without instructions.
Perhaps it is not correct, Lordship.
Why?
Lordship, I have stated in a paragraph, Lordship, here whatever their Lordship, actually Lordship, the Learned Council, that their Lordship, he telephonically instructed their Lordship several times, Lordship.
Who?
The council, Lordship, the official Lordship.
No, may have instructed, but can that be taken into account?
And the amount also paid by them, Lordship.
How do you know?
Lordship, even their personal Lordship also called with me, Lordship, what the telephone, Lordship.
No, with you over the telephone hardly matters. Taking into account that it has to be on writing, these are company things.
That writing, written writing, there is not, I don't know, Lordship. But Lordship, the learned council has always send a message, thereafter they come send
What
reply.
message?
WhatsApp message, Lordship. And amount fees you the WhatsApp message, Lordship.
By whom?
By as far as the legal officer, Lordship. He said that is the legal officer or whatever maybe, Lordship, he always, several times he sent the message, Lordship.
Huh?
When the discussion is going on, Lordship. When the discussion is going on between us, Lordship, then he sent message, he replied, Lordship. Then, Lordship, we instead of bargaining, Lordship, then we can see.
What is the status of the bar council proceeding?
Yes, Lordship.
What is the procedure, status of the bar council proceeding?
I have to take the instruction, Your Lordship.
Take that instruction and place it before this court as to what is the reply of the advocate.
Yes, Lordship, there is.
Because you are making an allegation and you should have made that advocate a party. Because you are making a serious allegation against him. Why you have not made him a party?
Lordship, actually, we took we have taken a steps before the bar council, therefore we did not.
No, you should make him a party also. Because you are alleging that he has done. So. We should hear him. He can also produce the text message. Normally, these are things which should have been done there.
Yes, so far I have taken the instruction. There may be some conversation, but no instruction was there to settle the matter. Because
what is there no
because the legal manager, he has to also take if any settlement is there, then he has to take the okay from the higher ups. He has to send them that this matter is pending. We may settle at this amount. He has to send to the higher ups. If the higher ups says,
no. If your legal manager have done that, he knows it. Then the question is different. It was a mistake of the legal manager to do so.
Mhm.
It is a different thing. That is your liability. Because the principle of holding out will apply. You file your reply out here.
Yes, sir.
And make that advocate a party.
Yes, sir.
Legal officers, Lordship, another in this case, Lordship, they filed, Lordship, this challenge, they have made another two application, Lordship. Both the applications are dismissed, Lordship.
The order we have annexed here.
This, whatever is challenge here, Lordship, to set aside the order of the National Commission, local Lordship. This challenge already is made in twice, Lordship. Lordship, kindly see page.
No, it's okay. They have done so. There's no quarrel with that. In fact, the question is, would there be a settlement in a local adalat without proper instructions?
That is correct. But that is also.
That is why in the council, that is why I make it a point out here. Here is a case, nowadays you see a lot of cases where the council, the junior council comes over, my senior is instructed to withdraw. The reason is tomorrow that particular person may say that I have not given him any instructions. My lawyer is so and so. So where is my instructions to give it to him for withdrawal? Similarly, in local adalat proceeding, if those people are not present, if it is done on the basis of the advocate, then people may very well say that no, I am not satisfied with this. So therefore, in most of the places you have the insurance people in the local adalat.
Yes.
How in an insurance proceeding, without the presence of the local adalat people, the insurance without the presence of the insurance people, the local adalat people, the local adalat function, it is also very serious. Here you must have appeared in many local adalat. You see the insurance people being there. to be present there. They
Yeah.
have to sign out
I
there.
know, Lordship, the council Lordship, he is shown the sort of message.
Council cannot accept. The reason, the main problem is the council cannot accept.
Message is there, Lordship. What's the message? He also shown the message, Lordship. That's
Council, why you are not understanding? Can the council accept? Is that power being given? He's not a power of attorney. He is holding only a wakalatama. He may be a standing counsel, but he cannot accept my liability. Can he?
There is the point, Lordship. There is there, Lordship. But so far I heard, Lordship, he was outside, Lordship, and he stated he's busy. That's why council was dealing with us, Lordship, and settled the matter, Lordship, and amount was fixed, Lordship. And in some Lordship, he also called our telephone, Lordship.
What was the matter about?
Matter was, Lordship, we took a loan, took some loan, Lordship, from them, Lordship, the finance company, Lordship. And Lordship, only the due to non-payment of 1 or 2 installment, Lordship, he snatched my vehicle, Lordship, and he sold out, Lordship. Therefore, Lordship, we filed a complaint, consumer case, Lordship. In the form, Lordship, they received notice, but they did not win their Lordship, and they avoided the proceeding, Lordship. That time, from below, Lordship, filed the expiry order, Lordship. The minimum amount was given, Lordship, only 3 lakh something, Lordship, only this much is awarded to me, Lordship.
So we set aside this, we get more money. Better.
Lordship, that money,
And it will start from that proceeding, from that question only. From the date when it has gone expiry against it.
thereafter, Lordship, he filed the first April, Lordship, if the state consumer firm. In the proceeding, Lordship, this amount is, Lordship, awarded.
First appeal it has happened.
Yes, Lordship.
In the first appeal.
First appeal it has happened. How did it go to the local adult?
Before the first appeal, Lordship, when the local said, Lordship, this honorable court, Lordship, proposed to Lordship, whether it can be settled or not, Lordship. Before
Because
that,
normally to go to the local adult, the concurrence of the parties are required.
yes, Lordship, that's what I see, also their Lordship. We, Lordship, give consent thereafter the matter was settled, Lordship. Thereafter matter was posted before the
You
local.
do one thing, you file your reply. In the meantime, we call for the records.
Yes.
And also, notice was sent by the onward state consumer forum also, Lordship. That is also paid, Lordship.
No, we do one thing, we call for the records of the file.
Yes, Lordship, maybe.
Better, huh?
Yes, Lordship. It is in the record, Lordship. Notice is some, Lordship.
But that is the big problem.
And Lordship, he also, Lordship, the legal officer, Lordship, he filed an ML, Lordship. Here he said that the matter was amicably settled before the court.
Where?
Yes, Lordship, kindly just change the Lordship.
Where?
Lordship, page 87, Lordship, there is the MA filed by the said legal officer, Lordship. Page 87, Lordship, no, it's given, Lordship. And legal portion of page 88, Lordship. Paragraph 3, Lordship. Here he says that although the matter was amicably settled before the national local adult, but this time also he knew that the matter was settled amicably.
This MA was also filed for setting aside the local adult order.
Who is the Supreme Das?
He is your lordship, he is the legal manager.
Council, tell me one thing. In paragraph number 3, at page 88, you say that a matter was amicably settled in the local. And thereupon you say that later on you came to learn that the vehicle was never possessed by you. And now you are trying to overturn the award. This is the scope and ambit of your application.
Yes, Lord.
So if this is so, what you stated before this court is wrong.
On our second
Kindly
petition,
come to page 3, paragraph 3.
Yes, Lordship. I've gone through it.
Then how this is possible? Because your reason why you are filing the order for recall is different.
Yes.
It is not for the purpose that you were never being given.
let me take some instruction, and in the meantime, we will file our reply here.
No, this is a very serious thing. All this person concerned, Supratim Das, you have come before this court wrongly. Your basic reason for seeking recall is not for the purpose that you were never informed by your lawyer.
In our second petition, we have
No, you cannot develop your argument for that every time. We impose costs. How much you got? 4 lakhs. Another 4 lakhs upon you. Upon your company for misleading the. All this person concerned, he should be present in the. This is not done. We'll ask him how it happens. List this matter again on 14th of November 2025. On which day the deponent of the present writ petition, Sri Supratim Das, shall be present in the court at 10:30 a.m.
What's up? 25.
Yes, we have. So we'll, we have found out the source, my lord, and the relevant rule, my lord. We have a notified rule. My lord, we kindly take up MMDR Act, my lord, section 50A. It grants the power to the state government to impose DMFT fund. DMFT tax, my lord, which he has been saying that no, there is no provision, you take it, you have to give it back. 15A. And personally 15A, my lords. Section 15A.
Good.
Yes. Act, my lord.
Act?
Act,
What
my lord.
This act,
1957 Act. my lord.
57 Act.
19 Mines and Mineral Development and Regulation Act, my lord. Power of the state government to collect funds of the district mineral foundation in case of mineral.
Section 50.
15A. It was amended, my lords.
What 58? There's no 58.
15, 1, 5.
15, 15,
1, 5.
15.
Where's the rule?
Eligible copy not be obtained at this point of time. Eligible. You will find two notifications. This is first notification, the voluminous one is of 2020, whereby my lord, this Assam District Mineral Foundation Trust rules has been given effect to it. But you will find the preliminary in the excess hours where 15A has been mentioned, my lord.
Where?
the very first part, first opinion, 15A has been mentioned.
What is the liability?
My lord, that another notification I have handed over, my lord, just 10%. And the where? 10%, the document, head of the God. Yes, yes.
Where is it?
Yes, no.
On the first page itself, Roman 2. নাই মই এইটো দিছো এইটো অৱস্থা পঢ়িব পাৰিব লাগিব this issue
Where is the power given? Means the power is there.
Yes,
How is it to be fixed?
well, this was SL before the Supreme Court.
As per this rule?
This was SL Supreme Court. This issue came up, man. It didn't settle that we have the power. Chandrabhan Singh, man. I'm still, well, we are still trying to find out the exact report. Detail affidavit will be required. Otherwise, that power was upheld. It's here also 10% was imposed. Then that could fund we should.
এইটো 25 আছে নেকি 25 যে amendment হৈছে যে তাই না
21 amendment.
This is a different rule.
No, my lords, still the section 15A has been discussed. 15A has been discussed by the Supreme
So
Court.
15A gives you the power
Yes.
to frame rules.
Yes, well, so we have framed those rules, my lord. The foundation.
Okay,
will be
but
notified.
where is it mentioned? The rules say how much, where's the prescription in the rules?
The 10% says, my lords,
In the rules, it has to mention.
that notification,
No,
second
there
notification.
will be something that that the state government by notification shall prescribe the rate. Where is it?
That says 10%, my lord. That second notification, that Roman.
Well, you
That's the reason
understand,
we are
or
asking.
should I say it in Assamese? The section 15A say the state government has the power to
Yes.
prescribe.
Yes.
The prescription is there in the Assam District Mine Foundation Trust Rules 2020.
My lords.
So in these prescription, there will be a mention as regards the rate. And if not, no rate is being mentioned, it will be mentioned that the state government by way of a notification shall fix the rate.
I get
This is why the prescription is there. Where is it?
my lord, this rate is not mentioned, my lord. But no.
So there will be mentioned that the state government by way of a notification shall fix the rate. Where is that?
My lord, this second lordship is holding, the Roman.
Council, are you
that was not
not
incorporated
understanding what am I saying? Or you are trying to not understand?
No, my lord.
Then
I'm trying.
I'm making it very clear to you. Section 15A permits the state government to prescribe for the purpose of the funds. On the basis of that, the Assam District Mine Foundation Trust Rules of 2020 has been made. Now, that rules will clearly say that what is how much it has to be paid, or the state government by way of a notification may fix. Where is that provision?
My lord, we are still into that. We are digging in it. We'll need some time. That's the reason we will be filing affidavit, madam. Because the other
Affidavit, we have given you the permission to file the affidavit, you have not filed.
my lord, the other notification lordship is holding, that just describes that is 10%. Point two.
That is a
So there's
fixing
a
for a
connection.
head of account. That is fixing a head of account. See the language out there.
It says district wise so and so. As ancillary charges a rate of 10% of royalty.
So that is head of account.
So there is a connection between these two, my lord. Why we are trying to find out, my lord. And this judgment relied upon with the petitioner, my lords. This will come to his help because this was a contract prior to the framing of these rules. This contract. But this contract which he is at present before the lordship is after 2020.
After
2020. This judgment was of 2019, it was a issue involving contractor total 15. The Vishnu Protein Bora.
2023.
Yes, my lord. Till now, my lord, we have got this only, my lord will request some little bit more time. my lord. And 2023, when he accepts the contract, it's clearly mentioned, there is nothing hidden charge, my lord. It clearly mentions DMFT 10%.
Incorporate করা নাই minor mineral concession যদি incorporate নকৰিলে এইটো কৰিলে
Parent notification of consider.
ইয়াৰ notification
Yeah, parent এখন আছে, তাত notify হৈ আছে।
তাত থাকিব
তাত আছে। PM ফাণ্ডত গুচি যায়।
deputy commissioner তাত যায়
Central Grant Credit.
This is it, Mr. Gogoi, you should be more vigilant. Kindly see section 9B5.
9B want to come to his help because 9B, Lordship will see kindly,
What?
section
9B
14,
won't work.
section 14, my lord. Section 14. Section 14 keeps away 9B from operating because 9B is for major minerals. We are dealing with minor minerals. Section 14, 5 to 13 not to apply to minor minerals.
Read 9B, then you come, because by 15A, 9B has been brought in.
Yes, that is okay. Lordship is correct. Now I just
So
have to
here,
find out-
therefore, 9B has been brought in by 15A. And therefore, see, in any district affected by mining of it, the state government shall by notification establish a trust, a non-profit body to be called the District Mineral Foundation. Kindly see 5, 9B5. This is how the 10% comes.
That we know, but we are trying to find out exactly 10%.
This is because the royalty, the equivalent to the royalty.
Shall be in addition. I didn't properly understand, madam, because that's the reason. Because it's-
Shall in addition to the royalty pay to the District Mineral Foundation of the district in which the mining operations are carried on, an amount which is equivalent to such percentage of the royalty paid in terms with the second schedule, not exceeding 1/3 of such royalty as may be prescribed by the central government. The holder of the mining lease granted before the date of commencement of so and so, and then covered shall in addition to the royalty paid to the District Mineral Foundation of the district in which the mining operations are carried on, an amount not exceeding the royalty paid in terms with the second schedule in such manner and subject to the categorization of mining fee and the amount payable so and so. Now kindly come to 15A. The state government may prescribe the payment to all so and so related to minor minerals of the amounts to the district mineral of the district in which the mining operations are carried out. Now, if you see, there is a provision by which 9B is being brought in.
In 2015, there was an amendment. Of 4 was brought in, of 15.
No. This 9B is being brought in by 2015.
Yes, please. It
And
inserts-
then 6 says, this has been amended by 28(3). Now 5 remains this.
So my difficulty is, my lord, will kindly come to 15. Just above, my lord, 15A. The amount of payment to be made to a district mineral by concern order reads without prejudice to, my lord, this rate. That amount, how they fixed it, my lord, that I have to come to.
Where?
Just above 15A, my lord. With, sub 4 was brought in.
Ah,
sub
this
4
is it.
Yes. The amount of payment, my lord.
Without prejudice to subsection 1, the state government may by notification make rules for regulating the provisions of the act for the following, namely, the manner in which the district mineral foundation shall so and so for the purpose of so and so, the composition of the funds of so and so, the amount of payment to be made to the district by concession of minor minerals under section 15A.
That is we are trying to find it. How this 10% is fixed.
No, yes, see, the state government may by notification make rules for regulating the provisions of the act for the following, namely the manner in which district mineral foundation shall work for the interest and benefit of the person and areas affected by the mining under subsection 2 of section 9B, meaning thereby that irrespective of minor or major, the state government has the power. So therefore you find this. So these rules are therefore being made under 9B, read with
15 and 15A.
15 and then 15A. This is being made under 9B, 15 and 15A. So therefore they are applying 9B also. 9B applies because there is one provision, if I remember correctly, some of the provisions of the act shall not apply to
States.
The state.
Because
But
my lord-
by this provision, they have in here,
Yes.
5 to 13, not to apply to minor minerals. The provisions of section 5 inclusive shall not apply to quarry, lease, mining lease, or other mineral concern in respect of minor mineral.
Because a state may contain uranium also, it may
But the
contain
problem arises out here,
How is
5 to
10%?
13, if it is not there, Means there needs to have been some amendments. The amendments, they did not consider 9B because this was done in 1972. You see, the amendments were made in 2016. So therefore, 9B would not come for that purpose. But then also the state has been given the power to formulate the rules in terms with 9B.
Because my lords, the state may contain both kind of minerals, major and minor. So central though has the power for major, we have been granted the power for the minor. But since the fund has to be one fund, it has to be diversified, so it goes like this. So what I'm trying to find out how that 10% is fixed. We have been charged 10%.
Now, what does the schedule, second schedule say? Second schedule, rates of royalty. Minor minerals are not here, second schedule, limestone.
Limestone, well, a few of them have been brought out.
10, yes, 10.
10 is there.
10, do you see? 20 rupees per ton.
Per ton.
10 is minor mineral,
10 is minor.
so this is 40. Now let us read 9B again. Because these rules otherwise they don't say so. The holder of a mining lease or a composite lease granted on or after the commencement of so and so 2000 or other than those covered under the provisions of so and so shall in addition to the royalty paid to the district woman of the district in which the mining operations are carried out, an amount which is equivalent to such percentage of royalty paid in terms with the second schedule not exceeding 1/3 of such royalty as may be prescribed by the central government. The holder of the mining lease so and so shall in addition to royalty paid to the district of the district in which miners are carried out on any amount on an amount not exceeding the royalty paid in terms of the second schedule in respect to such manner and public to carry out mining lease and the amount payable by the various categories of years as may be prescribed by the central government. So this prescription can only be by the central government.
But since 15A is there, 15A has been inserted.
No, but 15A, this is not 15A. Will come under section 15C, 15(4)(c).
Yes, 15A and 15(4)(c), but
This is the case under 15(4)(c).
15(4)(c).
So there the court, they has to fix the amount. Make rules for regulating the provisions of the act for the following. So rules have to be made for the amount of payment to be made. So if rules are to be framed, if these rules do not say so.
But these rules covers A and B.
Understood. It
But C
covers
doesn't-
A, but you have to say the amount of payment to
Yes,
be made by the
exactly.
district so and so
Yes.
by the consular of minor minerals. So therefore,
Yes.
these rules, it is the mandate of section 15(4)(c) that the state has to prescribe the rate.
So there is something, Malad. I have to link.
The rules does not say so.
Malad, these rules only cover it set up the trust, and it delineates its functions. But regarding C, Malad, we are still looking into it. So, and done with some time, because this will have consequences.
Good to have. And if your government is very negligent in that.
No, Malad, and the other part, Malad, isn't this person stopped by promissory estoppel? Because in 23, when he accepted the act, work, it was provided. Lordship, can you see the work order? Annexure 1, page 15, DMFT fund is mentioned there. All along he deposits.
How much?
It's my lord, DMFT against debt due rent, it's 43,000.
28,708.
Per kist.
Park East.
Where is Park East?
So you will see the schedule appended at page 16.
How many dead rents you have paid?
Total 8 kist, my lord.
You have paid 8 kists.
8 kist, my lord.
And how much you have paid as dead rent?
Total, my lord, 3 lakhs.
44,504 rupees.
But can you impose something in the name of something without there being a prescription?
There is, I'll find out.
No, you will find out there is a different thing, but without a prescription, how do you do it?
Such a cannot be without prescription. There is something. I'm trying to find out. Till now I have reached only this stage.
Earlier you have done it, we have set aside.
No, that was
Without those rules also you were doing it. So this time.
no
was-
earlier was due to our lack of diligence, we couldn't point out this 15K.
Or by an order dated 26/9/2025. But for the stand of the state respondent as to whether there is any provisions under the Assam Mines and Minerals Concession Rules 2013 or the agreement entered into by and between the petitioner and the respondent authorities for the purpose of charging an additional amount of 10% to the tune of rupees 344,504 on account of DMFT fund. Mr. D. Gogoi, appearing on behalf of the Mines and Minerals Department, isn't it? What is that? Appearing on behalf of the Forest Department, have placed emphasis upon Section 9, capital B, comma, Section 15 and Section 15A of the Mines and Minerals bracket Development and Regulation bracket close Act 1957. And further, placed before this court, the Assam District Mineral Foundation bracket Trust Rules 2020. This court have duly perused the said provisions as well as the rules so placed. From a perusal of Section 15(4) bracket C, it appeared that the state government have been empowered to make rules for regulating the provisions of the Mines and Minerals Development and Regulation Act 1957. The state government have been, by notification, have been empowered to make rules for regulating the provisions of provision. Even the making rules in respect to the field covered under subclauses A, B, and C of Section 15(4) of the Act of 1957. It is very pertinent to take note of that clause C of Section 15(4) specifically mentioned that the rules to be framed shall stipulate the amount of payment to be made to the District Mineral Foundation by the concession holders of minor minerals under Section 15A. Mr. D. Gogoi, appearing on behalf of the Forest Department, submits that he needs to make further research as to whether there is any prescription as regards the amount of payment to be made to the District Mineral Foundation by the concession holder of minor minerals under Section 15A, which is prescribed in the Assam District Mineral Foundation Bracket Trust Rules 2020. When? 2 weeks. List this matter again on 17th of November 2025.
Perhaps I got this. Because this notification which is said head of account, it is in continuation of some other parent notification.
There is a mention of it.
Yes, I'll
Find
find
out. But the fact is, by notification prescribed by rules, by notification prescribed by rules. Problem is, so the rules are to be notified, but the prescription has to be there in the rules.
Supplementary item 44.
Lordship, I got the instruction from the petitioner that they have received the amount.
Got the money?
Yes. Yes.
So our instruction says
You got the money?
So
Have you got the money or not?
petitioner told us that they got the money.
Huh?
They got the money, they told us.
Can you speak a bit louder for, because I have to record it.
They told us that they got the money.
Who told you?
Farida Chaudhary. Petitioner.
What is your name?
And Chakravarti. And Chakravarti. I'm on behalf of Mr. Irafik.
They are not there. You
Lordship,
cannot say anything. Okay, none appears on behalf of the petitioner on call. Mr. S.R. Pulva appearing on behalf of the petitioner. Submit that he is yet to receive instructions as to whether the petitioner has been duly paid the said amount. List this matter.
No, this is the instruction I have received. The last occasion it is come on 29/10. They were supposed to withdraw the matter. Then Lordship, I gave one whole instruction. Then Lordship, I was asked to provide you the instruction whether he has paid or not. But it is the latest instruction 111. It says Lordship, it is yet to be paid to the petitioner.
That is what,
Lordship.
that is what I said. Didn't I say that?
Yes.
Is yet to receive the instruction as to whether the payment has been made to the petitioner or not. Isn't that your case?
Yes,
You are saying that only.
yes, yes.
We can't trust her, taking into account that she is not a counselor. Okay. Taking into account the above, list this matter again on 17th of November for an update.
Lordship.
45.
And madam, ask your senior to appear. If you are not there in the Wakalatnama, you cannot make these type of submissions. Because if you make these submissions, I record. Did you hear what happened in the earlier case? In the Lok Adalat case, what has happened? These are cases where you need to hear about this. You cannot make a submission. Today you make a submission that you have got paid. I would have closed it. Then tomorrow that person may file a case against you, saying that you have not been instructed to say that. Be careful next time. I don't appear in this type of yes. Case is different.
Today morning we received the petition copy, Lordship. We need some time to file our response.
It is not the question of filing an affidavit. Have you seen the file? Have you seen the impugn order? Is it permissible to do so? This renewal in this manner? You had such term earlier that you will be renewing it for another 3 years.
Lordship, we are newly engaged in this department, Lordship. We have to take some instruction, Lordship.
You are newly engaged, but this is your department knew about this.
Lordship, today morning we received the petition.
Who gave you?
Lordship, petitioner.
Yes,
Today morning,
last night we have to WhatsApp, the scan copy has given to him.
Well, we have it next Friday, next Monday.
Lordship.
Get your instructions on this. Ms. So-and-so appears on behalf of the ASTC and submits that she would obtain instructions by next Monday as to whether the petitioner herein was granted a renewal without, under what authority? The petitioner was granted a renewal for period of 3 years by the influent order dated
Yes, no, no.
12/9/2024.
Not petitioner, my lord, not petitioner.
Huh?
Restaurant number 3 and 4,
Uh, No, for 3 years, no?
3 and 4 years, for 3,
Now the respondent number
3 and 4.
3 and 4 have been granted a renewal for a period of another 3 years. Under what authority was given? On number 3 and 4 have been granted a renewal for another period of 3 years by the impugned communication dated 12/9/2024.
What is it?
List the matter on 10th November.
Whereas, my lord, the matter virtually has become infructuous, because, my lord, page 12, the term of the settlement is expired. Although
What is it? What case?
settlement of market, my lord, although market was settled with the petitioners, but in the meantime, terms have expired, my lord. So it was up to 36/25. in June, up to June 25. Page 12, lordship will find. By this petition, although
Cut down the illegal private market operating in so and allow the petitioner to run the state so hard. What is this? Atajar Boramara hut. How can you run that hut?
Katarjar, yes, where the settlement holder, my lord. Because Katarjar, Guramara Hut, we are running. But nearby another illegal market.
Is this your private market?
No, this is my lord, it is government market under BTC. Katarjar is the BTC and the private respondents market is
Now, how did you get it?
so tender, my lord, the tender process.
And for how many years?
For 1 year, my lord. It has already been expired.
Then what it means?
Yes, my lord. That's why I'm submitting that it may have
Infructuous.
infructuous, my lord.
Mr. So-and-so submits that the instant writ petition has become infructuous in as much as the period of settlement of the petitioner of the Katajar Boramara Hut have already expired. Taking into account the above, the writ petition stands closed as it has become infructuous. I stands closed. Interim order.
No interim.
47.
It's regarding non-payment of contractual bills, your lordship. Last occasion, this honorable court directed to file an affidavit.
Yes, what is your stand?
Granted short time.
Next week.
After 2 weeks.
I gave you time from so many so many months, and it is going on from such a long period. Not having fun. 11/8, and today we are in the month of November. Then how much time do you require? 2 years.
Then, no, 2 weeks.
List this matter again on 19th of November 2025. A final opportunity is given to the respondents to apprise this court by way of an affidavit as to whether the petitioner is entitled to the any amount as have been claimed, and if so, and any amount as claimed, and if so, is entitled to any amount, and if so, how much, and when such payment will be made.
48.
In this case,
Ms. Enbora submits that 15 days time may be granted for the purpose of filing the affidavit. List this matter on 28 November 2025. The affidavit on behalf of the PNRD department be filed on or before 26th of November 2025.
And my lord, I may be allowed to submit my reply on that also, if necessary, lord.
And reply will see, let them file.
49.
Yes, before another 10 days time.
I've given you such a long time, then also you can't get your instructions.
It's my.
Then next onwards, we'll issue notice making it returnable in 10 days. Normally courts give it after 2 weeks, 3 weeks. I've given you 4 months and then also you
Yes.
can't get your instructions.
Yes, ma'am. I'm sorry, my lord.
It's a very sad state of affairs of the government.
I'm sorry.
Full stop. Ms. Udas, the learned additional senior government advocate, seeks for 10 days time for filing the affidavit on behalf of the respondents. List the matter on 1st of December 2025. The affidavit on behalf of the respondents be filed without fail by 27th of November 2025. So it is observed that if the affidavit is not filed, this court shall proceed to dispose of the petition on the basis of the materials already available on record and also applying the principles of the doctrine of non-frivolous.
Highly obliged, Lord. Now, please, your lordship. The respondent number 2 had filed an affidavit in opposition and we have received a copy. Lordship.
What did he say?
In paragraph number 6, they have stated mostly about delay in latches.
Huh?
Delay, about the maintainability on the ground of delay.
Very good.
And they,
Allotted in 2018-19.
yes,
You have come after such a long time. Why?
I have been continuously contacting with the department.
You continuously they would not help.
And after, that's why I have been,
Well, file your reply
Yes,
against this. So it is seen from the affidavit in opposition that the respondent authorities have opposed the instant proceedings on the ground that the work orders were issued in the year 2018 and 19. And the petitioner have not enclosed any such documents. It is further mentioned that in the year 2025, after receiving a liability certificate from the respondent number 3, the petitioner has approached this court. It is also mentioned that the petitioner have not filed any other document in that regard. The counsel for the petitioner submits that he may be given 2 weeks' time for filing a reply. This the matter on 26th of November 2025. In the meantime, the reply be filed on or before 24th of November.
51.
May it please your lordship. This matter is listed pursuant to your lordship's order dated 8th of May, August.
Yes.
There's the same dilemma, no? Work order is on 2012. Completion certificate does not have any memo number or date method, and that is of 2014. And their representation is 2024.
Dismissed.
These are admitted
So
among
what?
lordship.
These admission has no value. Tell me why the completion certificate has no date? Madam, tell me. These are all manufactured documents. Are you aware of this? Page 26. These are all manufactured documents. You better prove these before the appropriate court of law. I'm giving you, I'm not dismissing it, but I give you the liberty to go before the civil court, not this court.
Very well. Lord.
These are work orders of the year 2012. If this liability certificate has been given by this additional chief engineer, you see, this additional chief engineer liability certificate is not dated. How is it possible It is not impaired, nothing. No date, nothing has been mentioned. See, none of these are dated. You know the reason why? Because the signature, you cannot come up. Nobody will recognize the signature, who that person is. These are all short signatures put. See, this is how it is happening. Tell me page 32, whose signature it is? Can you say anybody? Can your petitioner say whose signature it is? Nobody can say. This is, and that is why no dates are given. He did this next page 33. See the signatures. Nobody can say who has given. No date, nothing. These are all these liabilities are. Therefore, I am calling one of these particular chief engineer on the particular the chief, additional chief secretary. na?
Right.
Yes.
JJM director.
So this is how it is given. Help it. Go there. Dismiss you.
Lordship, let me try I'll try before the civil court.
Then I'm giving you the liberty, and the dismissal shall not prejudice you in that civil court. That is also an observation. In that earlier case also, madam, the same order.
Very well.
I'm giving you because this liability certificate which they have given may have a problem with them.
Yes.
Although you have a problem with a recent judgment of the Supreme Court wherein it says if the period of limitation is over, there cannot be an acknowledgement to give you the benefit on the 19th. Be that as it may, the civil court may not know.
Not your blame.
We'll put that judgment of Kumbakarna. Yes. Yes, what is this?
Only interim was granted.
Huh?
Interim was granted.
Considering the above, this court therefore directs the respondent in the interim to reconnect the electricity in connection of so and so.
We have restored it.
Restored, and one you have disconnected. Then what remains?
Actually, wrong is committed by them, not.
Did you find anything? Because the person who uses is different.
As per them, my lord, I have get a telephony information instructions that one Prabhat Brothers electric connection still exists in that premises.
Remove that.
Yes, my lord. That instruction I have thought for my lord. I have time.
You get your affidavit file. Huh?
Yes.
You file an affidavit. Okay. List this matter again on how much time? 26th of November? List the matter again on 26th of November. Affidavit. In the meantime, the respondent number 2 and 3 shall file the affidavit on or before 24th of November 2025. Interim order passed earlier shall continue in the next.
53. On the last occasion, it was that it was filed affidavit. Here stand
Yes, what is this?
for FDC. Lord.
Affidavit filed?
No,
Why?
I am appearing on behalf of Mr. P. Sharma. Lordship. On
Appearing for?
P. Sharma, standing counsel for FDC. On 10th, he was admitted in hospital in Delhi. Lordship. So, affidavit couldn't be filed. Further 3 time may be granted.
When is your period ending?
My period is ending in 27.
What time is there? File your affidavit.
Yes.
Without fail. There cannot be any further adjournment on this ground. So many times, one time it has been taken. The AFTC, counsel for the AFTC as well as Ms. Yuda, you have also not brought on record the stand. No, directed to bring on record the stand. His stand in respect to the report on the basis of which the petitioner claims the adjustment of the case management. Because this is very relevant. You bring it by way of an affidavit. Because he is asking on the basis of your report. So therefore, he will have a good case. Help him. Yes. Miss, counsel appearing on behalf of Mr. of the AFDC as well as Ms. Yuda Talani, the additional senior government advocate submits the 2 weeks time may be granted for filing the affidavit. List the matter again on 1st of December, 3rd of December 2025. Full stop. In the meantime, the affidavit be filed on or before 28 November 2025 without fail.
For orders, item 27.
Application for implement not received.
We need some time to file this implement petition report.
Huh?
We need some more time to file
Okay.
implement.
It is seen that permission was sought for. Mr. Council, tell me, you sought for implement in the year 2024.
Not.
If you don't file the implement application immediately, wouldn't that limitation which is mentioned in section 20 of the Contempt of Courts Act 1971,
Lordship, the another aspect is that we have to also substitute the secretary who is.
we
also-
cannot allow you to file an implement application because otherwise the period of 1 year is over. 1 year is the limitation.
Lordship.
So by filing this implement application, 1 year you have already passed because 25/6/2000 council 6 times to file implement. So therefore the question does not arise. Now this court cannot. What is the order passed? My order passed. My order.
No, page 14.
What is the order? Question of cancellation of the registration of the AI is within the domain of so and so. Petitioner shall produce a certified copy of this order before response number 2 and within 6 weeks shall be counted from the date of receipt. And without expressing an opinion, response number 2 is directed to decide as regards the illegality and validity of the registration of the respondent in terms with the inquiry report, so submitted after giving an opportunity of hearing to both the parties. Then what happened? Another order passed.
Lordship.
You are asking for contempt for which order?
Lordship, the 2012-2021.
Huh?
2012-2021 Annex 1, your lord.
Violation of the order dated 2012/2021.
Lordship's order, Lord.
Till now what? You have not got that order?
Lordship, this affidavit they have been filed, additional affidavit.
Huh?
They have filed an affidavit by the respondent, your lordship,
Ah.
saying that your lordship, the order. Your lordship, the last line they have already stated that after considering all the aspects, I am of opinion that Honorable High Court may be apprised about the amendment of section 60. Only that much, lordship.
Where? Louis Chandra Bora, who is he?
Is the respondent number 2.
Fix the matter for hearing on issue where all the present, including private respondent, raised upon hearing the parties has passed a speaking order in compliance with the order dated when 11/2/2000 Iman. Peruse the representation submitted, peruse the order dated accordingly as date was fixed for hearing it. And heard all the opinion below. Who appears for the cooperation department?
The totally.
Okay, this order has been passed.
This order has been passed, but so far as per direction is issued, they have not indicated anything, just said that this section.
No,
60
they
has been-
say here, without expressing any opinion, is directed to decide the illegality and validity of the registration of the respondent number 6.
Lordship.
In terms with the inquiry report, so submitted after giving opportunity of hearing.
Lordship.
Now, if this is the direction being given,
But the, so
if the order is passed in this manner, you need to challenge this order. The fact that they have passed the order is a different thing. Whether the order has legality or has a legal sanction or not, you need to challenge it. I can't do anything as regards this. Because your thing is that there was no order passed. The order may be illegal, but they have passed an order. So the contempt cannot survive. I think you need to challenge this order. Unnecessarily keeping this matter pending doesn't help.
Lordship with liberty, Lordship.
Huh?
With liberty to challenge.
No, you
this.
can very well challenge it. Heard Mr. L. Mohan, the learned counsel, appearing on behalf of the petitioner. So this is an application filed alleging willful and deliberate violation to the order dated 2012-2021, passed in WPC number 5802/2017. So it is seen that pursuant to notice being issued, it is seen that on 11/2/2022, the Register of Cooperative Society, in pursuance to the order passed by this court, had passed an order. This court, Mr. L. Mohan, the learned counsel, appearing on behalf of the petitioner, submitted that the order on the face of it is illegal and does not appear to be as per the directions passed by this court. It is the opinion of this court that if the petitioner is aggrieved by the said order, dated 11/2/2022, the petitioner can assail the same on being illegal or unauthorized, illegal or on the grounds available for judicial review. Be that as it may, rightly or wrongly, the order has been passed on 11/2/2022 in pursuance to the order passed by this court on 2012/2021. And as such, the present contempt proceeding stands dropped. Liberty, however, is given to the petitioner to assail the order dated 11/2/2022, if so advised.
28.
Lordship, I appeal for R2 for a short accommodation. Being such the fine.
What is the direction passed?
Last order, my lord, that is 79/2025.
Read direction.
79/25. Yeah, direction 20. Page 20.
Non-payment.
Non-payment of contractual bill.
Ms. Bibuya appearing on behalf of the PTC, appearing on behalf of
Respond number 2.
the respondent number two submits. There's a new respondent, huh? Respondent number 2 submits that she has been recently, Mr. So-and-so, what's
Yes.
your name? Appearing on behalf of the respondent number 2 submits that they have been recently engaged. You have filed Wakalatnama or not?
Yes, today.
And as such, request some more time for obtaining the instruction as sought for by the order dated 17/9/2025. List the matter on 28/11/2025, on which date the respondent number, counsel for the respondent number 2 shall apprise this court as to whether the order dated 25/4/2022 passed in WPC number 588/2023 has been complied with or not.
29 and 31 similar.
29 and 31, same order.
Only I appear for R3, he appears for R3 in 29 and 31 R2.
And case number will be different. Huh?
On 2011.
Okay. What is item 30?
30 lot. 30, same prayer. Just on same day it may come,
Why? No, 30.
say non-payment of payment.
You appear for respondent number 3.
Respond number 3.
Mr. So-and-so appears on behalf of the respondent number 3 and sticks for some time to submit a order, same order. Can comply with that.
32.
What is this?
We have affected the dusty service upon respondent number 8 and 9 minutes as per order dated 13/8.
Service complete.
Service complete minutes.
What is the matter about?
There are two things, Millards. First of all, that it is filed by an union where Millards, two subjects were there, Millards, that the previous contractor did not pay the employment benefits. And secondly, Millards, the new contractor that has come, some people have been appointed, but the employment agreement is
Okay, service is complete otherwise.
Yes, Millards.
Okay, what is this IA business?
IUA was for the vacation of quarters, Millards. However, it will be the
Vacation of?
quarters. But however, subsequently, there was a notification advertisement where some people have been appointed, Millards. So these two this petition along with the IA may be disposed of, Millards, since respondent number 10 and 9 has appeared to them, Millards.
Service being complete. Service is complete.
Yes, Millards.
Service being complete, is the matter for admission on 19th November?
9.
Some more time, we need to file affidavit of original for 10.
2 weeks. 2 weeks has been given. Today, 3rd, 19 is fine. So many dates. On 19th of November, okay, 21st of November, the affidavit be filed on behalf of the respondents by 19th of November.
Kindly take it up on 24.
20?
24.
20?
24.
Okay, 24 Koirivo. Affidavit be filed on or before 20 November. By all the by admission, huh? IA, this you are not pressing.
We'll press along with the petition.
What is the IA business?
With the petition, Millards, it can be disposed of, Millards.
What is the IA?
Actually, Millards, some people, it was a vacation of quarters, Millards. So once the new contractor came,
Stay the notification dated demand issued by respondent and direct respondent to deploy the member. Okay.
I'm so glad.
What is the review petition for?
There is office note, the respondent number.
Huh?
They have appeared,
What is the IA for? I review of the order on behalf of the liberty which was given to the You are appearing for? Who is respondent number 5?
NSPC.
Okay, so there this problem is there, na? You are filing your affidavit. Affidavit in filed by 2, 3 and 4.
Yes.
You want to file an affidavit? Yes or no? 1 week. 2 weeks. This matter again on 19th of November 2025. In the meantime, the council's going to appear. In the meantime, the respondent number 5, who is being duly represented, shall file the affidavit on or before 17th of November.
Your Lordship, can I make a prayer for 25th or 26th?
What?
Your Lordship, I won't be around for
Hello?
26, Your Lordship.
19th of 28th of January. In the meantime, reply be fine.
Your Lordship, another prayer. In my affidavit, that I have wrongly, unrelated documents have gone in.
Absolutely not permitted. If you have unsolicited documents you have entered, we will initiate contempt against that person. Don't worry.
Deeply blessed.
It will further delayed. 28th of November. 28th. You file your affidavit by 25th of November.
Okay. They make it fine.
Who? They don't. They won't provide you. They want to put the blame upon you. Provide it. Yes, what is this?
My lord, on last occasion, your lordship direct us to implement a new party, that is civil executive engineer of Morigaon Jilla Parishad. Accordingly, we have filed an improvement petition, lordship.
Okay, you have made him a party.
Yes, lordship, I file a IL or that maybe take lordship together in this.
They have not come.
Not come, lord.
It has been submitted that an application has been filed for implement. This is the matter after 2 weeks along with the said application for implement.
35. Obliged.
May it please the lordship. Your lordship, we have been duly instructed by our client, that is the petitioner, to file a reply against the affidavit in opposition filed by the respondent authorities. Therefore, it is humbly prayed to your lordship to kindly grant us some time so that we can file the reply.
You got the 10,78,000?
Yes, your lordship.
Now what is left?
Your lordship, actually the amount was 15 lakhs.
Huh?
Actually, the amount which was admitted by the respondent authority was 15 lakhs. And now they are saying that as per the electronic evidence, it's rupees 10,78,222. But the physical evidence that we had provided in our writ petition, it was of 28 lakhs. So we need to file a reply so that we can put forward certain facts into the record.
Mr. Nath, last time I took up the issue as regards in the affidavit you have stated 15 lakhs.
But
Before in the writ court.
in the
Writ court.
in the affidavit, I have seen, lordship has called for the repetition record. I have seen the affidavit. In fact, not 15 lakh rupees is not the admitted liability for the petitioner. The letter is there, Annexure A. They said that you give us 15 lakh rupees, we have some liability to the petitioner, we have to pay. It is not as such that we are.
No, in the affidavit, let us see a record to petitioner.
Lordship has read.
In the affidavit, there is no mention.
In the affidavit, all of this annexure.
Filed by the respondent number 3
Yes.
in the writ petition. Where is the mention?
The deputy commissioner has annexed Annexure A, that is letter dated 30th of August 2023. By this letter, Annexure
Due
A,
to insufficient fund under the proper head, an amount of 15 lakhs has remained unpaid to the. Yes, this is a letter, this is not an affidavit.
Your lordship. Now, as per the affidavit filed against the writ petition by the respondent authorities, Your Lordship, may please come to the page number 481, where, okay, the court may not have the record
Huh?
of the affidavit filed by the respondent authority in the writ petition that was filed.
This is what I'm saying. 481 only I'm looking into it.
Your Lordship,
This
in
is
the-
madam, this is a letter. This is not based on affidavit. In the affidavit, there is no mention that the 15 lakhs is due. That is what I am saying. Therefore, I call for the records. You do one thing. I close down the affidavit, now this contempt, on the basis that you have received 10,78,000. If you have any claim, go and file the suit before the civil court.
Because they have a claim for 28 lakhs.
Who?
Sir,
Originally-
Your Lordship,
originally their claim is
petition.
28. They can-
So you can very well claim the remaining amount.
One little concession, my lord, because the party has instructed us, the petitioner has instructed us.
Huh?
Petitioner has suggested us, my lord, to file a reply to the.
Mr. Counsel, can you be a bit louder? Yes, now
my lord,
tell
the
me.
Petitioner has suggested me, my lord, to file a reply to the affidavit that they have filed,
Okay.
putting forward some facts, man. I think it is, and thereafter your lordship is quite.
But the
quite
question out here is whether there has been a compliance or not.
My lord, absolutely.
Now, if the order says 15 lakh, whereas the affidavit does not disclose to be 15 lakh,
My lord, the
would it be
question is-
proper on the part of this court or on the basis of a mistake made by this court to enforce an order and direct them to pay?
My lord, I'm not
The
on.
best option would be giving you the liberty to proceed and file civil suit if so necessary in respect to the remaining.
Very correct.
I think that is a better
my lord,
course of
if-
action
if-
because
if-
I can't adjudicate many
My
aspects
lord,
of the
if it
matter.
is there, my lord, I'm not taking advantage of that order simply because the 15 lakhs is reflected there. So I'm going for that. I'm not that. My lord, to the extent, my lord, I think I
We
need
do
to
one
file a
thing.
reply.
We do one thing, we take
Well-
it up again on day after. Day after, on Thursday, we take it. Tomorrow also, we can take it up at 2
My
p.m.
lord, what,
and
what,
finish it off.
what I say, my lord, I need to file a reply. Little,
You
two,
want to
three
file a
pages
reply?
for that.
The counsel appearing on
2 weeks.
behalf of the petitioner submits, the petitioner would like to file a reply to the affidavit in opposition filed by the respondent. Accordingly, list this matter again on 3rd of December 2025. In the meantime, the affidavit is filed.
Deeply obliged.
Deeply obliged, Your Lordship.
36.
May it please your lordship?
No affidavit filed.
No, your lordship.
Hello, we ask these people to appear. Which department?
AFDC.
Managing Director, Assam Fisheries Development Corporation. Who, somebody appeared? Okay. Anyways, madam, we have this matter some other day. Now I don't want to pass an order at around this time. Okay, list this matter again on 10th of November 2025.
37.
Yes, madam. Did you inquire?
Yes, your lordship, as per this instruction, your lordship, file is pending in the judicial department, your lordship, we have taken our steps to send it for the finance department for payment, your lordship. Your lordship, it is 410 and 1310. Since then, the files are pending before the judicial department.
We do one thing.
Yes, sir.
We just give an update on the next day. I give you 1 month's time. Miss Ardika, the learned standing counsel of the Water Resource Department, At pursuant to the order passed by this court on 22/8/2025, I placed an instruction issued by the Chief Engineer, Water Resource Department, that active steps have been taken for the purpose of making payment to the petitioner, payment to the petitioner, his dues, he or his or her due, continue his or her dues. And in that regard, has also approached the finance department. The council submits that most likely upon the finance department's approval, the payment would be made to the petitioner. In that view of the matter, list this matter on 8th of December 2025 at the motion stage for an update. Motion stage, for an update.
38.
38.
It's a separate order. A copy of the instructions is kept on record and marked with the letter X. X. 39. Shortage of stamps?
Oh, yes, your lordship. Day before yesterday, I have been informed, your lordship, but I could not deposit the stamp, your lordship. Actually, recently, your lordship, the system speed post has been introduced, your lordship. And registered post. With your lordship.
The scene when Miss Enbora, the standing counsel of the PNRD, has placed before this court an instruction dated 1/11/2025 issued by the Block Development Officer, Kalayan Development Block, wherein it has been mentioned that due verifications are being carried out, and as such have sought for some time for giving an update. To list this matter again on 24th of November or on 5th of December for an update. The instructions so submitted is kept on record and marked with the letter X. This is the matter for admission. Huh?
Look, I filed a rejoinder today.
What is this?
No, this is that unauthorized construction by the private respondent. And lordship had directed status quo on the last day. This matter may come up for admission, my lord.
List this matter for admission. Why the matter has come up today?
Immediately the respondent number 530 is the municipal court.
Have they filed?
No, they have not appeared, my lord. They have not. Why should I take fresh step? I have taken thus the service.
Respondent number 6 has filed.
He is respondent number 6.
Taking into account the office note, list this matter for admission on 19th of November?
No, 19th, I mean some difficulty. Towards the end of November.
21st?
He's saying December.
I have to run through the record.
The first week of December.
If found necessary, then I will have to.
When? When do you want?
On December.
Okay, on 5th of December.
Look, the status quo order may continue. Status quo order may
The interim order passed earlier shall continue in the next.